Good afternoon and welcome. This is a regular meeting of the Sunshine Ordinance Task Force called for Tuesday, March 22nd, 2011 at 4 p.m. and beginning at 4:02 p.m. Roll call, please.
Yes, Mr. Chair. Member Snyder? Snyder absent. Member Nee?
Here.
Nee present. Member Cawthon? Here. Cawthon present. Member Manny?
Present.
Manny present. Member Washburn? Washburn absent. Member Knebber? Knebber present. Member Costa?
Here.
Costa present. Member Wolf? Wolf absent. Member Chan? Chan excused. Member Johnson?
Here.
Johnson present. Member West? West absent. Mr. Chair, we have a quorum.
Thank you. Are there any agenda changes?
There are no agenda changes, Mr. Chair.
Okay. We do have a request for continuance on items number 12 and 13. That would be Matt Smith against the district attorney. The complainant has been called away on a family emergency and requests continuance. Is there a representative here from the district attorney's office? Okay. Without objection, we will continue this matter until our next regular meeting. That would be on April 26th, I believe.
April 26th.
Any other changes to the agenda? Member Mr. Rustin?
Mr. Chair, items 2 through 6 would be preferably continued because I have received permission to add the minutes to the timing to the minutes, if you want to.
Okay. Without objection, items 2 through 6, those are the minutes of various meetings having taken place between January 4th and February 22nd, 2011. Without objection, those items are continued. Any other changes to the agenda? Member Johnson?
Through the chair, does that mean that you may receive permission to put the time in?
Through the chair, that is correct.
Thank you.
Further agenda changes? Seeing none, Mr. Clerk, could you call the first item, please?
The first item is special recognition to Marjorie Ann Williams for her community service as a member of the Sunshine Ordinance Task Force.
Thank you. Ms. Williams, could you please step forward? This is kind of bittersweet. Ms. Williams served, I believe, longer than any other member of the task force, and she had to leave the task force under circumstances that you just don't wish on anybody. The fact that you stayed on the task force as long as you did through those trying circumstances, Ms. Williams is to your undying credit, and we wish to really, from the bottom of our hearts, we wish to thank you, and I have a little presentation to make to you.
Oh, thank you. Oh, my name. Thank you. Thank you so much. Thank you. Thank you.
Feel free to address the task force at this time.
I just want to say it is bittersweet, and it looks like Sue Cawthon and I was here at the beginning. I was going into my 12th year, but I'm like a she-wolf. I found another pack, and I'm doing post-traumatic stress counseling, so things work out the way they work out. So, and Jerry, we go back a long ways, and you're still here. But being on the Education Department committee is very, very important. And Sue, keep it up with Hanley, because there's still a lot of people out there that do not understand what their rights are and what this committee is all about. And I'm like Arnold Schwarzenegger. Don't look like I'm going somewhere, because I might be back. I might be back. And the new ones that's on this board, be committed and dedicated to both sides. but really be true to your constituents, which is the general public. Be sure they get a fair shake. That's what I'm all about. It's about the people, you giving your service to the people of San Francisco. And like Mr. Grossman said the other day on television, open government means good government. And that's what we need, is open government. And I want to thank each one of you for your thoughts, and especially Member Nee. Member Nee will pick up that phone and call me and send me a little note and see how I'm doing. I'm hanging in there, and everything is going to be all right. But most of all, I want to say to little bird dog group out here, to my little army friend out here and all the ones out here, I'm going to miss you guys the most. I'm really going to miss you guys the most. I'm going to miss your little uppity arrogancy when you come up here like a soldier. I like that. And Mr. Grossman, I'm going to miss you guys too. And I'm going to be thinking about you. And please get these amendments, because whoever said that the sunshine is dead and it's no good, that's a lie. We moving forward. And call on me at any time that you can, and thank you, each one of you. And I'll be seeing you. I don't say bye. I just say, I'll be seeing you. And Sue, keep me in the loop, okay? Call me when you need me, because I'll still go on education with you, okay? And thank you so much. Okay.
At this time, would the members of the task force like to put in some words to Ms. Williams? Member Kneber, Member Coffin, Member Monick.
I knew Member Williams before I came on this task force, and I was involved in community groups. And every time I've come in contact with you before this task force, and especially on this task force, I've always been impressed with how committed you are to making sure people are heard, making sure that people feel that their concerns are heard, and that you want them to feel comfortable with the system. And I try to keep a kernel of that inside of me. Every time I hear somebody up there that I feel has gone on too long or is off point or whatever, I try to think about you in the way that you always encourage people to speak their mind and allowed them the support and gave them the support to get whatever they needed to off their chests. So I wanted to thank you. And I hope everything in the future works out well for you.
Thanks, James. Okay.
Well, we do go back a long way, and I've enjoyed every moment of working with you. I mean, you're always so cheerful. You have such good ideas. You want to make sure that the public is involved, but you're not. You also want to make sure that the department has a voice. So I'm really going to miss your smiling face, your gorgeous wardrobe, and your pungent comments.
Thank you so much.
Member Bonet?
Yes, I really wanted to thank you because you, maybe most of all, I mean, everyone here on this task force and the usual folks who are just so supportive and instrumental to voicing their opinions. I mean, everyone has their place in my heart, but you have a really big place in my heart and memory, because I will never forget the very first meeting. It was at least a few years ago, maybe, when I first started this on this committee, and I remember you pulled me aside and you said, "We need more people like you. We need new people. We need fresh blood." And I remember you went on and on and on about how you were there to, in case I ever needed you, and you've always been so supportive of all of us here. So I just want to echo all the thanks that we've given you so far. You've just been wonderful, so thanks so much.
Hey, thank you.
Member Johnson?
Member Williams, I only served with you on the task force for a short amount of time, but I want you to know that I wholeheartedly echo Member Kneber's words, and I'm always going to remember very specifically that there was a young man who came in here before us, and he was from the Fillmore district, and he wanted to find out about why the city attorney's office spent so much time about the Muni substation. And I was very struck by you telling him and reminding us that it was very rare for a young man and a young African-American man to strike out on such a mission and how determined he was. And I am never going to forget that. And that is going to stick with me the entire time. So thank you very much. And I hope you do think about coming back if you find the time.
Member Wolf.
Hi, I'm Marjorie.
Hi,
You
Bruce.
look so beautiful today. Thank you so much for all your years. I mean, I've actually been digging back in past archives and keep seeing your name over and over and over again. So I really appreciate and I'm honored to have served with you on this task force, and also in the spirit of social work and the spirit of diversity. And I really appreciate your holding the mantle on these things. So I wish you the best in the future for whatever you do.
And thank you. And think about me, because I'll be thinking about you. Okay, thank you.
I just want to echo what our colleagues on the task force have said. And even though you're not on the task force, you obviously care deeply for Sunshine. And so if you have anything that you want to convey to us between now and the time that you rejoin the task force, we would love to hear from you. And thanks again.
Thank you. Thank you. Thank you very much.
Before we proceed with the agenda, I believe the representative from the district attorney's office is here. Ma'am, the complainant has been called out of town on a family emergency, and he has requested continuance. So since you were not here earlier, that was the decision we made. Okay, so this matter is continued until our next regular meeting of April 26th. Thank you for coming. Mr. Clerk, could you call the next item, please?
Yes, Mr. Chair. The next item is item number 7. The Education, Outreach, and Training Committee has, without recommendation, referred 10036 Thomas Piccarello against the SRO Task Force back to the Sunshine Ordinance Task Force for further proceedings because the order of determination was issued against a now defunct administration.
Okay.
Can we have public comment on item number 1?
No action.
It's not an action item, sir.
Out of respect to Ms. Williams.
Go ahead, please.
Follow the chair.
My name is Ray Hartz, Director of San Francisco Open Government, and Margie Ann Williams and I have a shared bond in that we both took the same oath to protect and defend the Constitution of the United States from all enemies, foreign and domestic, and to bear true faith and allegiance to the same. And I think she feels about that oath the same way I do, which is once you take it, you can never lay it down. And I have to say, on all the times that I had a pleasure of being before this committee and this task force and hearing her, I never disagreed with one of her comments, and I always felt that deep inside, every comment she made, every vote she participated in, included her belief in the strength of our country and the fact that it rests upon the Constitution of the United States, the Constitution of the State of California, and in the Constitution of the United States, the Bill of Rights. And I think as a member of the African American community, she did immense amounts of good to give them a voice when many times they are denied that voice in city, state, and federal government. So I think she deserves every accolade she received. And believe me, if I could make up a statue of gold, I would give it to her in a second.
Okay, thank you. Further public comment on item number 1.
Yeah, I want to echo the same comments as Mr. Hart's. Ms. Williams, in my opinion, was one of the strongest advocates for open government, sunshine, and transparency amongst the task force members. She's certainly going to be missed, and I would hope that her successors have the same passion that she had while she was on the task force. Thank you.
Thank you. Further public comment on item number 1. Seeing none, public comment is closed, and we have the clerk has already called item number 7. Is the complainant present? Okay. Please approach the microphone. Sir, thank you for coming. You have 5 minutes.
Well, there's already been an order of determination, a finding against the SRO task force for denying the public comment and the ad hoc meetings. the whole purpose of this hearing today was to produce Ms. Cronenberg, who was chairman of the SRO task force. I don't see Ms. Cronenberg here today. So once again, I'm in front of you on an order of determination without the respondent present. So I don't know what more to add other than you need to figure out how to compel Ms. Cronenberg to appear in front of you. Thanks.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Is there anybody here to present facts and evidence in support of the respondent? Is there anybody here to represent the SRO task force or the Department of Public Health, which I think is the parent body, is it not?
Mr. Chair, it is now handled by the Department of Building Inspection.
Department of Building Inspection?
Yes.
Okay, thank you. Is there anybody here from the Department of Building Inspection? Okay, seeing none, the matters with the task force.
Mr. Chair, at the...
Mr. Rustin?
Thank you. At the Education Outreach Committee, the new chair came and spoke to the committee and said they had nothing to do with it because it was a past administration and referred it back to Ms. Cronenberg.
Okay. Member Johnson?
Yeah, I was on the Education Outreach and Training Committee at that time, and the new chair of the SRO task force was there with another member, and complainant felt confident that the new chair was aware of what had occurred. But we, at the Education and Outreach and Training Committee, were disappointed that Ms. Cronenberg had not contacted the Sunshine Ordinance Task Force or made an effort to appear. And again, we referred it here because we didn't think that just by transferring Ms. Cronenberg should be relieved of her. She also had not shown up previously, which is why the order of determination had a 6721E for failure to send a knowledgeable person. So the intent of sending it back to the task force was to recommend we refer her to the Ethics Commission for failure to appear.
I have a question that perhaps one of the EOT committee members or perhaps Mr. Picarello could answer, and that is Ms. Cronenberg with a new body or employed by the city now? Does she have any connection with the city at all, Mr. Picarello?
Yeah. After violating my sunshine rights, she was promoted to head of Department of Emergency Services. So now she heads that department. And Ms. Johnson is correct. I guess the reason it's in front of you is to deal with the issue of, if a head of a department violates sunshine rights and then gets promoted to another department, he or she should still be compelled to attend the task force and answer the allegations in a complaint. So Ms. Cronenberg does work for the city and county of San Francisco. She was promoted. She's now head of the Department of Emergency Services, or Emergency Management, however it's called this year. But once again, she has failed to show.
Thank you. Okay, at this time, the complainant, since the respondent is not present or represented, the complainant will have 3 minutes to make any concluding remarks, if you wish.
I'll just add that the SRO task force now is much more open, and I've had no problems with the SRO task force now that there's a new chairperson, Ms. Bosk. So there are no issues with the SRO task force as presently constituted. The problem was Ms. Cronenberg, and she continues to be the problem regarding my complaint.
Okay. Thank you. Is there a motion? Member Johnson.
I would move to forward this to the Ethics Commission against Dan Cronenberg for 6721E for failure to appear.
Second.
Moved and seconded. Is there discussion? Is there public comment on this item? Thank you for coming, sir. You have 3 minutes.
Thank you, Keem Crossman. I would concur with the proposed motion and also recommend adding a violation, willful failure violation 6734. She's a management employee and she hasn't complied with your order. So not only is she not appear to your task force, but she's not complied with your order. So I would add that, i.e. official misconduct.
Thank you. Is there further public comment on this item?
Having dealt with the Department of Building Inspection, it's no surprise to me that it hasn't yet recognized that this task force has been in existence for over 10 years, probably, 15. This is an example of the kind of finger poking in the eye that you get when the press is full of statements from the city attorney and from the executive director of the Ethics Commission that is defamatory of the group, that undermines its authority, and it gives the departments and their department heads and city officials the feeling or the impression that they don't even have to show up. I think what you would do is to send it to ethics, make it clear that some representative, knowledgeable representative from the Department of Building Inspection, particularly Ms. Cronenberg, should be here for these hearings, because that's a requirement under 6721E. Thank you.
Thank you. Further public comment?
Task Force members, Ray Hartz, Director, San Francisco Open Government. And I think that Ms. Cronenberg probably didn't show up for the very same reason. I see a lot of people in executive positions, especially those that are required to sign an order stating that they understand and are responsible for the implementation of Sunshine in their departments. They don't have a valid reason to argue the case. They did something that they did. They have no real grounds for defending it. And as a result, they're embarrassed to show up here because they know that they would be here pitter-pattering around trying to dance and come up with some explanation for something that they have known throughout the process they had no right to do.
Thank you. Is there further public comment? Seeing none, public comment is closed. Member Cawthon?
Yeah, I just wanted to say something as somebody who's been on this body since before Prop G passed. I really am concerned that the departments have been so remiss in coming to our meetings, and I'm not quite sure why that is. But I do know that we don't yet have any real means of enforcing edicts against the non-conforming departments. So I hope we can hurry up and finish up with the amendments to the ordinance so that we will have, a stick to encourage people to cooperate with us.
Okay. Further discussion? Seeing none, roll call, please.
On the motion, Member Cawthon? Aye. Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Knebber?
Aye.
Knebber, aye. Member Costa?
Aye.
Costa, aye. Member Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Member Wolf?
Aye.
Wolf, aye. Mr. Chair, we have 7 ayes.
Thank you. This matter shall be referred then to the Ethics Commission. Could we call the next item, please?
Next item is hearing on the status of the January 25th, 2011 order of determination in 10054 Ray Hartz versus the Library Commission.
Thank you. Is Mr. Hartz present, please? Thank you for coming, sir. You have 5 minutes.
Task Force members, Ray Hartz. The first thing I'd like to point out is the determination itself. I have a couple of questions about. Number one, under order of determination, it's dated February 7, 2011. I did not receive this until March 16th, which was last Wednesday. And I think that if that date is supposed to be the date of issuance, it would be a lot more honest to put that down there so that it was clear that, number one, Mr. Rustum did his job. He sent this in. I checked with his boss, Mr. Caldeira, and he turned this in for review on February 7th. And it was 5 weeks before it was finally issued. The second is in the section saying findings of fact and law, and it's the second paragraph quoting, it also noted that the task force has found in a previous ruling that placing the 150-word statement as an addendum was acceptable if it was mentioned in the body of the minutes, and that is factually untrue. I made an immediate disclosure request. Mr. Rustum came back and said there was no such ruling. There was something mentioned in a previous case, and he said DeWitt versus the MTA, I believe it was, but there was no determination and no ruling in that. So that statement is factually false. You have not made a ruling saying that the law didn't count, because the law says in the minutes. And if you want to have a discussion on that, I don't deny your right to do that. I put this complaint in originally because of one primary reason. I believe in two major things. One is that the city has an obligation to give public records to somebody because they don't belong to the city, they belong to the citizens. And most importantly, they have an obligation under the law at so many levels to allow public comment. They have no right to deny public comment. And I'd like to give kudos to Sue Coffin, who took the Library Commission and got them to accept the fact that they have an obligation to allow that comment. I would also like to point out how, though, that the Library Commission refused to attend most of the hearings in that matter. They have continued to denigrate it and ignore it, even though the Ethics Commission has determined that she was exhibiting comment below that expected of someone in public service. They still treat it like a joke. In fact, they treated this one like a joke, because when I brought it up at the meeting, and they had a little discussion, the comment from Ms. Gomez was, quote, "Sunshine Ordinance statement is not a law," unquote. So her attitude is basically, I don't think it's the law, I don't care what they tell me, and I'm not going to do it. Very frankly, what they want to do is they want to preclude public comment. They tried to do that. Ms. Coffin took them to this task force and got a determination. They can't do that, but what they now want to do is ensure that any meaning from those comments ever make it into the minutes of the meeting. They do that for two reasons. Number one, they don't like what people say, which is a violation in itself, I think, of the Brown Act, because it says in the Brown Act that what it is, what doing things like this is to silence public comment and maintain the status quo. In this particular case, they don't want my 150-word summary or anyone else's put in the minutes because they would be, by necessity, next to their summary, their editorialization, their censorship of our comments. And I think it would become very, very clear, anybody reading those minutes would see what that person said, and what they summarized as they said had nothing to bear in relationship with the actual statements that were summarized by them. They basically want to have total control, and they want to make sure that even though you got to say it, it'll never appear in the written public record. And I'll tell you one thing. What they're trying to do is deny those words, and by extension, those thoughts. They want to deny you access to a full, fair hearing in the view of the public. They want to make sure that the public never hears your words. And I will be willing to predict right now that even if you do side with me and you do take the exact wording of the Sunshine Ordinance and order them to put them in the minutes, they will ignore you, just like they have every other determination issued by you. They will simply say the city attorney told us that we cannot do that, and they will just, again, show their contempt, not only for the law, but for this body.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Thank you for coming, ma'am. You have 5 minutes.
Thank you. Good afternoon. It's nice to see Ms. Coughlin back on her feet. I'm Sue Blackman. I'm the Library Commission Secretary. And I just want to say that the Commission and myself were very disappointed that this task force did not continue after we made several requests for a continuance of this item at the last time it was heard. Having said that, we have made changes to the minutes. I have a couple samples if you want to pass them around. We have added a comment or a statement in parentheses after the speaker makes their comments that says, see addendum for a 150-word statement submitted by the speaker. And we have also made the addendum language and the summary statements at the bottom of the minutes more prominent by making it in bold. So we have attempted to respond to your information, and we have discussed this with the city attorney, and they feel this is appropriate, and we are in compliance with the law.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Member Wolf.
Ms. Blackman, please.
Yes.
Mr. Hartz the complainant had testified that that the chair had verbally refused to follow the Sunshine Ordinance. Is that true?
No, that's not true. I think she did. I think she was making a statement that we were complying with the law and that we were complying with the good government guide and the advice that we're getting from the city attorney.
Okay. How do you determine whether you are in compliance with the law?
From the advice we get from the city attorney.
Okay.
And the direction from the Library Commission to me for how they want the minutes.
Well, I'm not necessarily speaking to you as secretary.
Right.
You're here representing
the commission.
So I'm talking with regards to the commission. You're aware that the good government guide is not the law?
Correct. The good government guide is the city attorney's advice on how to follow the law.
Okay, great. And when the city attorney offers you advice, how do they go about doing that?
Usually verbally.
So it's to you directly? It's not like a general memo that goes out to every...
No, we have requested a memo on this case from the city attorney's office, and we are waiting for a reply from them.
Do you make recordings or
Yes.
Are you videotaped?
Yes.
You are.
Mm-hmm.
So what is included, do you feel that whatever is included in whatever video or audio video that is recorded is part of the record?
Yes, absolutely.
Do you believe that that the minutes are part of the record?
Yes.
Okay, so wouldn't it stand that whatever's in the audio video should be also included in the minutes?
Well, we don't do verbatim minutes.
I understand that, but there are guidelines to how the minutes are to be done, and so if a person's testimony is presented, it should be paraphrased in the minutes.
Correct, and I make every attempt to do that. I will admit to not being perfect, and I think in the one example that Mr. Hartz brought up, my summary probably wasn't as good as it could have been. They cover a lot of our various speakers cover a lot of different issues at any one time in a 3-minute segment, so without verbatim putting it in, it's sometimes difficult. But I will say that I do go out of my way to put any negative comments or any constructive comments that they make in the minutes. It's not just, when they make positive comments, I definitely go out of my way to try to do that. And I will say, when Mr. Hartz first came to the Library Commission, he did say these were the best minutes he had ever seen at a commission meeting in the city.
I'm not going to argue that point. That's your work. But what I'm concerned about is instruction that you get from your superiors on the commission, do you feel, or within regards to the advice you've gotten from the city attorney, feel that they have in any way instructed you to do less than?
No, absolutely not. I mean, they would like my summaries to be more brief, to be perfectly honest. I try to encapsulate, as much as I can for the speaker every time they come up.
Okay. And the last question I have is are you aware that the Sunshine Ordinance frowns upon addendums for this purpose?
No.
Okay. Thank you very much.
Member Johnson.
Ms. Blackman, I'm not sure whether you had said in your statement, did you say that the city attorney had advised you that an addendum was appropriate and you were not going to change it?
No, we've changed the minutes to add an addendum and put within the body of the minutes the language that says within the body, see addendum included in the minutes.
In the order of determination, the attorney who's not here, Member Snyder, had said that in 6716 it says that the 150-word summary, the specific language says in the minutes. And
Correct.
If I remember, which doesn't mean attached to the minutes, it means in the minutes. And if I remember correctly, in this particular instance, the original minutes were so abbreviated as to not suggest that it was a negative comment, and then the comments at the end may have been, I don't want to say missed, but if somebody were to just read it, they wouldn't be looking for what Mr. Hartz had actually said.
I'm going to agree with you. In that one instance, I did not capture the summary very well.
And then my other thing is if I also remember correctly, I tried your meetings are, whether they're videotaped or audio taped, they are not available online.
Correct.
So that makes it even a little bit more difficult you can't, if you're just a regular member of the public, I know that they're available by getting them. But just to make you aware, the task force has interpreted in the minutes to mean in the minutes. And I understand that your summary of them can't be as detailed as perhaps they would like, but the point is that if they've provided the actual words, it's really just cutting and pasting, depending on how they provide them to you. But it's if you review it and you feel that what they said was not accurately reflective of what actually happened, that may be a different matter. But Mr. Hartz's, you captured the law that he was referring to, but not the negative quality of it.
I completely agree. I missed the summary on this one, having gone back and looked at it, and I probably should have been more careful having the 150-word summary. But I think in my mind at the time, I was somehow thinking that the 150-word summary was there, not to make an excuse for, but I just missed it.
Okay. Thank you.
Member Coffin.
Yeah, I just wanted to say I go to all the Library Commission meetings, and the minutes are really complete. I almost think they're too long. But there are times when I feel that I have not appropriately been characterized in the minutes. I just don't say anything. But on this particular issue, the 150 summary, where does it belong? I know we've had this before, even though Mr. Rustum couldn't find any record. I think a man named James Chafee, who always goes to the library commissions, brought it up. And I somehow remember that we did not object to adding this at the end. I do think, however, the content of those 150 words should be definitely summarized in the minutes.
At this time, the respondent and then the complainant will have 3 minutes each to make any concluding or rebutting remarks. Ms. Blackman? Okay, Mr. Hartz?
Task force members, first thing I'd like to point out is that this body determined what the law means, not the city attorney. And nowhere in the Good Government Guide does the city attorney say that basically, he has, that the Good Government Guide is anyway a legal thing. In fact, in the beginning, in his introduction, it says the following, quote, "So please be prudent. Understand that no publication can substitute for the careful consideration of the application of laws to specific conduct," unquote. And basically what I'm saying is this is in consideration something that they're failing to do. They're failing to take into effect what the law actually says, and they're deciding to do what they want to do based on their permission they're granted. Now, going back to Ms. Cawthon's comments, one of the things I have noted continually at the Library Commission meeting is while they will allow members of the commission to make changes to the minutes before they approve it, when members of the public disagree with what their statements, how their statements were presented, they are allowed to get up and say it, but they're never changed. They change their ideas, but if you object to the way yours is represented, they won't change yours. And I would like to finish. How much time do I have, Mr. Rustum?
Through the chair, 1 minute, 36 seconds.
I'd like to read from the Brown Act. Public meetings of governmental bodies have been found to be limited public fora. As such, members of the public have broad constitutional rights to comment on any subject relating to the business of the governmental body. Any attempt to restrict the content of such speech must be narrowly tailored to effectuate a compelling state interest. Specifically, the courts found that policies that prohibited members of the public from critical school district employees from criticizing school board employees were unconstitutional. These decisions found that prohibiting critical comments were a form of viewpoint discrimination and that as such promoted discussion artificially geared toward praising and maintaining the status quo, thereby foreclosing meaningful public comment. And I think honestly that is what they're doing, and I'll give you an example. I took this same complaint to the Ethics Commission, and what they did is on their website, they put everything in. If you go to the website and you print out the minutes, you can't see my comments. If you look at the minutes on the website, you can't see my comments. What you have to figure out is there is a specific sentence in the area where my comment will be that if you click on will bring up a link in Adobe Acrobat, which will then show my comments. So if you don't tell them in the minutes, what they're going to do is they're going to find a way to ensure that members of the public who review their minutes will be much less likely to ever see the public members' comments.
Thank you. The matter is back with the task force. Member Kneber, Member Cawthon.
This is the same problem I had when we first heard this case. It's again, we're down to a difference of opinion between us and the city's attorney's office that the Library Commission seems to want to follow. I 100% agree that we need to, part of, I'd say the essential part of public comment is having the person's actual comments available for somebody to read when they look over the agenda and see what happens. And I understand I'm not holding this particular case. I think is just indicative, and I understand it's been asserted that there was a mistake about how it was perceived in the comments. But again, I think at the base of it, it's again a difference of agreement between us and the city attorney, and the Library Commission wants to follow the city attorney.
Member Cawthon.
I did have a question for Ms. Blackman. Hi. Mr. Hart said that when he goes online, he can't pick up his 150 words. Is that correct?
He was talking about the Ethics Commission. It has nothing to do with ours. Our minutes are just as you saw them. When you click on the minutes on our website, you get the complete document.
Including the 150?
Including the 150.
Okay, good. Thank you. Yeah, I just wanted to say, for those who don't know, that I had a complaint against the Library Commission because I was prohibited from making general public comment, and the Ethics Commission did indeed side with me. We have not had the final hearing because of my illness, but we're going to. But I do think, well, I think Ms. Blackman really wants to be helpful. I do think there is a pervasive feeling on the commission that it doesn't really matter what the public says.
Member Wolf, and then Member Washburn.
Yeah, I'm a little concerned about the statement that's in the findings and facts and conclusions that the task force had found in previous rulings that the addendum was acceptable. Since 2005, that I've been on this task force, that subject has never come up, and it's never been discussed. So I have no idea where that comes from or what history that comes from. And if, as Member Cawthon said, that Mr. Rustam had tried to find some reference to it and hasn't found any, then I don't think that it's appropriate that it be included in the findings of fact and conclusions of law.
Let me respond to that for just a minute, and also to put that entire matter in perspective. My own recollection is that in the past, the task force did find, whether it was an actual ruling or not, I don't remember. But the task force did, I think, consent that appending comments at the end, not necessarily the verbal comments at a meeting, but written comment submitted, appending those at the end was okay, as long as there was some kind of indication in the body of the minutes that that addendum was there at the bottom. Now, having said that, I will add that I think that's almost irrelevant here. If you read the final section in this order of determination, decision and order of determination, there are specific instructions there, and that's what we're working with. Were those specific instructions complied with? That, I think, is the matter in front of us. Member Knebber.
Yeah, I would like to add to what Chair Nee said. I think that we're getting confused between the ruling that if somebody provides a 150-word statement, they are allowed to add it as an addendum. I think this is a little bit different because Mr. Hartz read his statement, and the idea here is about the summary of that statement and the addendum. I think they're two separate issues. I agree that Mr. Hartz has an issue with the addendum, but I remember that this case was about the summary of that addendum, if I'm not mistaken.
Member Washburn, and then Member Johnson, and then Member Wolf.
A couple of things. My memory matches yours, Chair Nee, regarding a decision a year or so ago about saying it was okay to attach the 150 words as an addendum as long as there was mention in the body of the minutes, a reference to the attachment. But I think the issue the issue here is whether or not Mr. Hartz's statement was accurately reflected in the minutes, and we decided that it wasn't. Mm-hmm. So there is a problem with writing summaries, and particularly if, as Mr. Hartz says, they could never be corrected. So you have the public's words misrepresented, forevermore, and that's a real problem. Attaching the actual text that the member of the public provides, as was done in the minutes that Ms. Blackman provided us, I think helps, certainly. But not all members of the public prepare written statements, and so it's important that the summaries be accurate. And, I don't know what we can say other than, I think going forward, and I think this might be a matter for EOT, is helping secretaries of commissions recognize the importance of accurate summaries, but also providing for commissions to provide members of the public an opportunity to correct the record. And finally, I just want to say that the minutes we have before us, I think, are for January 20th, 2011, are quite good and quite detailed, and in contrast to our own minutes, which don't reflect public comment at all, and which I think is disturbing. I just wanted to remind everybody of that.
Mr. Threet?
Through the chair, I just want to note a couple of things for clarification. The order of determination and the decision at the end has the paragraphs that say decision in order of determination, and that paragraph includes two violations. The task force, at least as reflected in this order, found two violations. One was that the summary was inaccurate and therefore an abridgment of the public comment. And the second is that attaching the statement as an addendum and rather than placing it in the body of the minutes was a violation. So there's two separate violations in the order. So there's been, I think the order has been described different ways and the decision of the task force has been described different ways, but the order itself has two violations.
Thank you. Member Johnson, Member Wolf?
Mr. Threet did hit upon one of the things that I wanted to ask the task force about, but I also wanted to let task force members know that in the draft of the new ordinance, you did make a statement that it was okay to attach statements as an addendum. And the reason I remember that very specifically was before I was on the task force, and I wanted to ask about it if we were going to continue to make those changes. So that is something that has been put out there, and it says it in the order of determination. So as a newer member of the task force, I prefer the interpretation that Member Snyder made. He's not here to back that up, but the exact wording says that the comments shall, if no more than 150 words, be included in the minutes, not attached to the minutes, not somewhere near the minutes, not able to find in the minutes, but in the minutes, which is very black letter law. So because there have been two areas where we, as a task force, whether it was current or not, interpreted 6716 in two different ways, including on the order of determination, I think that maybe, and that the city attorney had given the Library Commission also a separate view. I think that the Library Commission has tried to handle it in some way. I feel like they're trying to comply with that particular part of the order, although I would prefer that the task force lean on the side of in the minutes in the future, because that we can back that up with the language. But the 6715, where about altering Mr. Hart's statement, even though it was maybe not intentional, I think respondent has admitted that that was violated in this particular instance.
Member Wolf?
So I agree with Member Johnson and DCA Threet's statements on this. The addendum is of what we're here to determine today. That is before us. The 150-word statement that could be submitted is meant for a number of things. It's meant for people who are unable to attend the meeting that want their statement to be made part of the record. It's also meant for if people feel or were not able to finish their full statement and there's additional information in the written statement that they want to be also made part of the record. So their voice is fully heard because it's there in writing too. And I agree also with the interpretation that Member Johnson has of the Sunshine Ordinance, that it's not an offer but a directive that it be included in the minutes. So I don't think a general opinion or statement by anyone on the task force is of any legal binding. What's legally binding is what this task force rules. So I think that we should adhere to that and find move ahead to find a violation of 6716.
I have a question for Mr. Hartz. And I'm sorry if I'm making you repeat anything here. Maybe it went right by me.
Oh, believe for
but
me, it's no problem.
Well, okay. On the question of the violation of 67.15, altering your statement, has that been corrected?
No, it never was. Basically, what
So
I
in
do,
the
I can
minutes
show
that
you
you're
an example.
in the minutes that you're talking about, the alteration of your statement is still there?
Yes.
Okay, thank you. Is there a motion?
I move to find a violation of 6715, 6716, and Ms. Gomez in violation of 6721.
Okay, those violations were already found.
Oh, okay.
The question now is, where do we go next? Do we want to refer this to ethics or the Board of Supervisors or the district attorney or the state attorney general or any combination thereof? Member Kneber.
I don't think we can refer to the district attorney because they're saying they're following that advice. So I think that's a dead end. I think ethics commission is probably our only option, and I would support that.
Is that a motion?
Yes.
Is there a second? Is there a second? The motion dies for lack of a second. Is there a further motion? Member Johnson, Member Cawthon.
Member Cawthon had been raising her hand before me,
Mr. Nee
if that's okay.
Mr. Nee
I apologize,
Mr. Nee
Member
doesn't
Cawthon.
notice me. In any event, I like Member Washburn's idea that this be sent to the Education and Outreach Committee, of which I'm a member. I think that Ms. Blackman is really dedicated to trying to sunshine. I do. I've had a lot of contact with her. And it does say in the ordinance that the addendums be included in the minutes. So I think possibly we could work with her and see if that could happen instead of having them at the end. So that would be my... I don't know if it should be in the form of a motion. I would just ask the chair perhaps to refer it to the Education and Outreach Committee and let us work with Ms. Blackman on it.
Okay, and please, I did not mean to ignore you. Member Johnson?
Is that a motion?
I don't think it needs a motion.
No motion required.
I would
on
ask
this.
for a referral
that's exactly what I was going to say.
I was going to ask for a referral
almost.
from the chair.
Okay, is there any other motion? Seeing none, this matter is referred to Education, Outreach, and Training Committee. We'd like to,
Public comment.
we'd like to invite, at this time, we'd like to invite public comment on this matter, even though there's been no motion, sir.
Kimo Crossman, I think EOT is a good approach for this. And I do want to commend the library for having detailed minutes and at least in some fashion summarizing what people say, which oftentimes does not happen currently at here at SOTF. Unfortunately, the current version of the ordinance does not allow for people to provide written comments if they can't attend, and they can't elaborate. What it says is that any person speaking during public comment may supply a brief written summary of what they said, basically. So that's always part of the ordinance I thought should be changed to allow people to submit 150-word comments even if they can't attend, and not have it be limited to exactly what they said, but maybe after hearing what other people said to put their 150-word summary there.
Thank you. Further public comment?
I really think you have a chance to fix something that is prevalent within the community that's served by the city attorney, that being all the boards and commissions that have minutes taken, I don't know where the notion came from that the word includes means attach. The plain dictionary definition of includes would not allow that. But more than that, it suggests to me that this is simply another way in which the city attorney has turned some of the issues that are come before the task force upside down. For example, we now have 3, 6, 8 members here. Mr. Costa, you should know that in order for any motion to pass, 6 members out of the 8 must vote affirmatively. Not 5, which would be a majority, but 6, because there are 11 members of this body, and under the charter as interpreted by the city attorney, that means every member is counted whether he's present or not. So you have 3 empty seats as we speak. Keep that in mind. The other thing is, if you look at the minutes that were produced by the Library Commission on the last page, agenda item number 6, adjournment, public comment none, motion action adjourned. Then there's a next full paragraph which reads explanatory documents. And then there's about 15 lines of explanatory documents not referring to any attached public comments that have been provided. The point is that this is simply another device that has been endorsed by the city attorney through the Good Government Guide to discourage public comment and open government. The last thing I want to say is this. I'm sure you're all familiar with a quote from Mr. Dorsey. I've only got the New York Times piece, but this is what he said about you. The task force has degenerated into a rogue, lawless jury that beats up on city departments and tries to get conscientious public employees fired. For that reason, he has now established a position that the city attorney, who is the advisor to this task force, is antagonistic to it. As my understanding, as a lawyer who practiced well over 50 years, you have a fiduciary duty to your client and a duty of loyalty. And you cannot, repeat, cannot disparage your client in public. And for that reason, I would hope at some point during this session that you will ask Mr. 3 to withdraw. Thank you.
Thank you. Is there any further public comment on this item?
Thomas Piccarello. First I want to thank the representative for the Library Commission for showing up and complying with the Sunshine Ordinance. Secondly, I think the task force showed good judgment in not referring this out to the Ethics Commission, District Attorney, or the Attorney General, especially when the Library Commission is relying on the City Attorney as to what to do and not to do. But finally, let me say this. I want to thank Ms. Washburn for her comments regarding minutes. If you expect city departments and city agencies to comply with 6716, then you need to lead by example and comply with 6716 yourselves. Thank you.
Thank you. Is there further public comment on this item?
Hi, how are you? My name's Chris Coughlin.
Microphone, please.
Pardon?
In the microphone.
Yeah. My name is Chris Coughlin. I'm a San Francisco resident. And my comment basically deals with, we're dealing with all commissions that I've spoken to in San Francisco. And I find that basically people try to do the right thing, and they try to go talk to commissions. And most of the time I've gone, and especially at the Planning Commission, what I find is that they're not listening to anybody anyway. And they've already made up their decision, and the public comment is just a formality to stay within the law. What I'd like to see this organization do, and you might already do it, I don't really know, but I'd like to see you at least put together your findings weekly, publish them somewhere. Get city funding, whatever. even put them in the Examiner. Make sure that obviously they need to be on the web. but contact local newspapers, like I'm from the Sunnyside Neighborhood Association. Contact Neighborhood Association and ask them to, put this information in their paper, at least a link to this information. Because I think that the people of San Francisco actually believe that good government is happening. And just sitting here for 10 minutes or a half hour waiting for another matter to come up, I see that my experience is like everybody else's. You go to these meetings and they're not listening and they're not doing anything. So I applaud you being here and taking the time to shed light on city government. So anyway, that's all I had to say. Thank you.
Thank you, sir. Could you assist our clerk, please, by spelling your surname?
Coghllan.
Thank you.
Thanks.
And thank you for your comments, sir. Is there any further public comment on this item? Seeing none, public comment is closed. And again, this matter is referred to the Education Outreach and Training Committee, and thank both the complainant and the respondent for attending and appearing before us. Mr. Clerk, could you read the next item, please?
Yes, Mr. Chair, the next item is public comment.
Public comment. Right, general public comment.
Yes, this is a time for general public comment. Thank you, Member Wolf. This is time for general public comment on items not on today's agenda, sir.
Yes. My name is Robert Clark, and what was previously mentioned was that there was a New York Times article on the Sunshine Ordinance that was published on March 17th by
18th.
An individual, and in that article, I'd like to quote some of the comments that were made by some of our city officials, which I found outrageous. Matt Dorsey, spokesman for the city attorney's office, said in an email, the task force has generated into a rogue, lawless jury that beats up on city departments and tries to get conscientious public employees fired. Mr. Dorsey and other city public information managers said they spent an extraordinary amount of time and resources complying with the ordinance. They described the task force hearings as a tedious kangaroo court. John St. Crow, executive director of the Ethics Commission, said that the work of the task force often lacked due process and that his department had an obligation to review the cases. Now, I've only been coming to this task force recently, and in the time that I've been here, I think this task force has done an outstanding job of giving fair hearings to me and the other members of the public comment. I've been going to city meetings and committees for almost 40 years, and in those 40 years, I have never been before a public committee that has at least given me a fair hearing. I've lost a few of my hearings. I've won a few of my hearings. And when I read these comments by the city attorney, I just was flabbergasted. I couldn't believe what he was saying. And I realize now that what we, the public, are up against when we're trying to confront the city attorney and some of these commissions. And I just wanted to say to you that don't let these statements influence you. You people are doing a great job, and I want to thank you for it.
Thank you, sir.
My name is Jason Grant Garza, and I unfortunately have quite the opposite to say. Oh, boo-hoo, you people are doing a lousy job. As a matter of fact, in 10038, my case, which wasn't heard till after the 45 days, which was pushed up to the Ethics Commission, I just got the result back from the Ethics Commission. You guys didn't do anything right. It says right here that you didn't even report them under the right ordinances, that you're basically incompetent. Now, unfortunately, I've been coming here for 10 years to see how this game is rigged. The shrills for the city right here. Yes, we're here to help you. 10038 has been out for 9 months. Ask me what help I got on this IDR. And then when you pushed it up to the Ethics Commission, they just overruled you. So to offer, like I said, false hope, false process, makes you as evil as they are. It's an illusion. Also, I wanted to also say that soon I will be heard over my matters when it comes to whether or not I need to have a HIPAA release form signed. And when it's proven that it's not, I certainly hope you'll reconsider 10038 and the bait and switch tactic in which I was thrown, which I got 5 out of 6 votes, which of course went against me because of the rigged system that this all is. So I hope that when I prevail in the future, you'll have the stones to do the right thing.
Thank you. Is there further general public comment?
Task Force members, Ray Hartz, Director, San Francisco Open Government. I will be the first to admit, and I think you know, that we've had our differences over the years. But when I read the articles that were quoted from by the prior folks, I wanted to make sure that I came here and told you it has absolutely nothing to do with you. Those comments are dishonest. I can think of a dozen different terms to apply to them. What they are really is a reflection of the city attorney's attitude toward open government, public record law, the Brown Act, and more importantly, the Constitution and the laws of the state of California, the Constitution of the United States of America, and the rule of law. Anything the city attorney doesn't like, he will denigrate. I've had the same experience when filing cases against the city attorney's office, and the city attorney will show up and instead of talking about any of the issues, will denigrate my character, my motives, all these other things. And I've always been very curious as to how they discerned any of this when they had never actually had a conversation with me. And they knew nothing about me. I served in the United States military for 12 years. I took that oath that I mentioned to you earlier, and then I spent the next 12 years of my life doing exactly that. And when the day I took the oath, I had an awakening. I just all of a sudden realized that oath was never going to be something I was going to be able to lay down. And when I go to a library commission meeting and I start to bring up issues of free speech and free government and following the rule of law, the Sunshine Ordinance and so forth, and I watch them sit up there and roll their eyes and make derogatory comments and other things, I know one important thing. It says much, much, much more about them than it says about me. And these comments that were made in the New York Times and in the local press say much, much more about our city attorney and his attitude toward the law and the rule of law and open government. And this is the man who wants to be our next mayor. Can you imagine that if he makes it to mayor, what the city hall is going to be like? It'll be like Wisconsin, where they lock the doors and you only get to come in if you take an oath of loyalty to them. I don't think he will allow anything to be said with which he disagrees. He will disregard the Brown Act, the California Public Records Act, the Sunshine Ordinance, any other thing you want if it serves the interests of his way the city should be run. And if he makes us a city attorney, I will probably, unfortunately, as much as I would hate it, leave the city.
Thank you. Is there further general public comment?
Thank you. I'd like to make a short statement on a similar note. I just want to read from the minutes of the January 25th, 2010 Arts Commission meeting, a statement that was made by President P.J. Johnson. He stated that President Johnson recounted that he was once the public information officer for the city, and he understood that Proposition G He understood that Proposition G changes to the Sunshine Task Force made it very simple to call city agencies to task. Unfortunately, it has unintended consequences and has sometimes been abused. He cited the case of an employee in the health department purposely using it as a weapon to disrupt the department's operations. He said that the requests can be so onerous that they completely gum up an agency's whole process so that all the staff can do that's all the staff can do. President Johnson explained that the city attorney's office doesn't spend any more time than they have to on these requests, and advised departments that while they may sympathize, the departments must comply. He thought this was a real problem throughout the city and eventually has to be addressed. So obviously you don't have a friend in Mr. Johnson, who was formerly the information officer of the previous mayor, and I'd just like to make you aware of that fact. Thank you.
Thank you. Is there further general public comment?
Actually, I was pretty serious about the fact that the city attorney's office cannot represent this group anymore. Period. Full stop. For the city attorney to say this about one of its clients, and we know the city attorney makes a big point out of the fact that it represents the task force and the departments, it can no longer, Mr. Herrera and whoever's on his payroll can no longer represent the task force. That means Mr. Threet shouldn't be sitting here, or if he is sitting here, it should be just to hear what you have to say, but not to give any advice. Having said that, again, I want to point out Mr. St. Croix's quote. You heard part of it, that there was no due process before this board. And then he says, 14 of the 27 cases were dismissed based on advice from the city attorney's office that other laws took precedence over the ordinance. Well, that's a pretty serious statement. If it were true, which it's not, because of all the people sitting in this room, I'm the only one who saw all of the records in all of the files on all of those 14 cases. That was my lawsuit. And I can assure you that of the first 8, every one of them was based on a lack of, quote, of substantial evidence to support. No word about the city attorney. My favorite, though, was the case that I had that was referred to the Ethics Commission involving the district attorney. There was only one piece of paper in that file. One. It was a memorandum dated in December 2007 from Paul Henderson, Chief Administration, to John Croix, St. Croix. It was received and marked filed on December 14. No indication how it got to Mr. St. Croix. The referral letter from this body is dated January 8, almost a month later, and was sent on January 31 of 2008. Now, how is this possible? That case was dismissed based on that memorandum from Mr. Henderson. There was no due process. There was nobody talked to me. He didn't even bother to read the file. I read it, and this is the proof positive that this man cannot tell the truth. He doesn't know how to, and if you ask him a question that he doesn't want to answer, you will get this kind of an answer. No due process, and all these cases were dismissed based on the opinion of the city attorney. Some were. I mean, the silliness is so blatant. I'm sorry, but I'm pretty angry about it.
Thank you. Is there further general public comment?
Hi, Keem Crossman. I want to say that my perspective on Mr. Dorsey's comments, which I understand the email actually said some even more outrageous things that were not quoted in the article. But the way I see that is that it's political posturing by Herrera's office. You know, Herrera's going to have to deal with all the complaints as he runs for mayor about Sunshine and how his office has not supported Sunshine. So this is kind of a preemptive attack to come out and cast you guys in a bad light so that when people say, well, you know, why hasn't Sunshine been supported, then, you know, say, oh, it's a kangaroo court and it's Star Chamber and all that. So that's how I see it. That's the motivation that I believe is behind Mr. Dorsey's really outrageous comments. And also to try to reduce political support for any amendments that might come up to the ordinance in the future, to set a negative tone in the press and the public about the Sunshine in general, so that if you guys do come up with stronger amendments in the future, then they can try to control the message. I do remember a time when Mr. Dorsey was quoted as claiming that sunshine request that I'd put into the city attorney's office had shut down the whole entire city attorney's office. And you know what? City attorney, as we know from Mr. Threet's very limited support of you these days, he actually has to, city attorney and all the lawyers have to record the amount of time they spend on each task that they do. They complete a time card, unlike some other professionals. So I said, well, you're saying that you shut down, that my request shut down the whole office. Show me the time cards. They didn't have them. So the point is that Mr. Dorsey basically had to walk back his comments on that outrageous claim, and maybe someday he will walk back these comments as well in the future. But right now I see his what he said, and also Mr. St. Croix is mainly posturing and trying to I would just look at it in a positive way that you're obviously having some effect if they're having to come out so publicly against it. And I would actually think that was probably a badge of honor.
Thank you. Is there further general public comment?
Thomas Piccirillo. You know, if the quotes are accurate by the city attorney, you probably do need somebody else representing the task force rather than the city attorney's office. My suggestion is to speak with the city attorney and see if that's his philosophy, and if it is, then excuse me, then perhaps you should suggest to the clerk's office and the board of supervisors that you have outside counsel. I've been following the board of supervisors now for the last 3 years, and I have noticed a lot more closed sessions by the city attorney's office, especially this year. The city attorney is now running for mayor. In fact, you have a complaint coming to you, hopefully next month, excuse me, regarding a closed session matter. And that segues into my comment regarding my own complaint that was filed a couple of weeks ago. Generally, the complainants get something back in 2 or 3 days, acknowledging the complaint and setting it for a hearing. This matter is against the Board of Supervisors, the Budget and Finance Committee. I've heard nothing back from your staff. In addition to that, I notice your logins for complaints shows my complaint, but it doesn't show a respondent on your log list. So I'm hoping that the Board of Supervisors is not intervening regarding my complaint. Thank you.
Thank you. Is there further general public comment?
Yes, good afternoon. Peter Warfield, Library Users Association. Sorry, I came a little bit after public comment started, but certainly the comments that were being discussed that were carried by the press with regard to the city attorney about this body, I think outrageous is a good word. Appalling, in other words, might be applicable as well. What I was disappointed to see in the paper was an absence, as I recall, of any indication that the city attorney office itself has been the subject of quite a number of findings of violation against Sunshine by this body. And that was an unfortunate omission, I think. And furthermore, if the city attorney thinks that this body is a kangaroo court, perhaps the city attorney ought to give this body more support instead of pulling its deputy city attorney out of here early and lacking the support that long time ago you at least attempted to, the office attempted to give this body through much more scholarly and, if you like, background information in preparation for your determination hearings. There was a time under a previous deputy city attorney, although these were not of the highest quality in my opinion at all times, nonetheless there was an effort to inform you about your own history of rulings and other related matters that might bear on your hearings. Now you essentially get nothing from the city attorney's office to help you with the history of that section or the history of your rulings, et cetera, et cetera. So in many ways, I think that those things are relevant. I think that you should have a hearing yourselves on what the culpability has been of the city attorney and of other city bodies that routinely, and especially when they're wholesale violators, what's going on and why. With respect, so I think that some action from this body would be suitable, if not as a direct response, perhaps as a background or indirect response to review relevant material that might bear on the subject of whether you're a kangaroo court or not. With respect to another matter, the format of your orders of determination, I think, has in some ways improved and in some ways has not. The attempt to place in context the actual orders that this body prepares by surrounding it, in a sense, with a frame, a contextual frame that apparently the chair has been writing. I believe that's who's writing them. I think makes some sense. In the past, some of the orders have been very bland and incomprehensible. Unfortunately, in the case recently before the public library, that led to the library quoting from prior sections that had been quoted within the letter and making it sound as though this body endorsed the illegal actions that you had actually found in violation. Thank you.
Thank you. Is there any further general public comment? Seeing none, public comment is closed. Mr. Clerk, could you read item 9, please?
Item number 9 is the Compliance and Amendments Committee has referred file number 10059 Dorian Maxwell against the San Francisco Municipal Transportation Agency back to the task force with a recommendation that MTA Director of Bus Operations David Hill be found in violation of Section 67.33 for failure to instruct MTA employees under his leadership on sunshine requirements, and that the matter be forwarded to the Ethics Commission.
Thank you. Is Mr. Maxwell present, please? Thank you for coming, sir. You have 5 minutes.
Good afternoon, Sunshine Task Force Ordinance. My name is Dorian Maxwell. The SFMTA and their designees have great disrespect for the transit operators. When we request information, it totally gets ignored. The SFMTA management staff is cocky, arrogant, and feel that they are above the law. As you know, since September 27, 2010, I was placed on non-driving status while the SFMTA attempted to terminate my employment. The arbitrator decided to reinstate me with 15 calendar days suspension because the SFMTA fabricated charges against me for picking up political materials off the floor and discarding them. They were already on the coach when I received them in relief. The emails definitely showed that. During my Skelly hearing, I was kicked out, threatened to be escorted out by the law enforcement. The SFMTA at that time did not furnish me any documents for review at my Skelly hearing. I took a week vacation off so I can just have a level mind to deal with this matter. On my first business day back after returning from vacation, I requested in writing under the Sunshine Ordinance that I requested this information. That request got ignored, and I was convicted without any means of defending myself. This information that they were withholding would have convicted the other operator. This action never transpired, and the other operator got off scot-free. If this happened to me, you can imagine how many other operators that got suspended, wrongfully terminated on non-factual information. If the operators knew about the Sunshine Task Force Ordinance, they could have information to have access to their information that may or may not exonerate him and her. On January 25th, justice was served when the Sunshine Ordinance Task Force ordered the SFMTA to furnish any and all documents relating to my case. That order was ignored. It took over 5 months to get this information, and finally I got it at the last hearing that I attended. During this hearing, Ms. Chambers gritted under her teeth, demanding that I come up here and tell you guys that she helped me with this information. And after the hearing, she said in a very low voice as we were walking out the door, "Thank you, Dorian, you just got me fired." I also had another matter before the Sunshine Task Force, case number 10066. On January 25th, the Sunshine Task Force Ordinance ordered the SFMTA to furnish all signed letters and addendums to the current MOU. I have yet to receive that information, and they do exist. It is evident that the SFMTA management staff thinks they're untouchable when it comes to the law. You have another case on today's calendar, 11006, where the SFMTA was asked to furnish public records, and they failed to respond to that request. I think this and other matters regarding the SFMTA business practice should be referred to the Ethics Commission as long as the State Attorney General's office. Along with that, it needs to be an investigation on the SFMTA business practice. There may be some criminal activity going on at the SFMTA. The ethics charges should not just be limited to David Hill, it should apply to others as well. And I do hereby suggest that the Sunshine Task Force Ordinance use the parliamentary procedures to entertain a motion to include, but not limited to, David Hill, and the following names should be added: Nathaniel Ford Sr., CEO and Director; John Haley, Director of MTA Transit; Deborah Johnson; and Chris Abora, Director of Human Resources, to be found in violation of 6733, failure to instruct the MTA employees under their leadership of the Sunshine requirements. Forwarding this matter to the Ethics Commission is greatly supported by myself, and I have two other co-workers that would like to speak out on my behalf. The Sunshine Task Force Ordinance should send this to the Ethics Commission in the State Attorney General's office to send a message to the SFMTA management staff, David Hill and others, that ignorance of the Sunshine Law is no excuse. Ignoring the information request under the Sunshine Law is a serious offense. The aforementioned directors should be held accountable for their negligible behavior in respects to information requests.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Thank you. You have 3 minutes, sir.
Yeah, my name is Chris Coughlin, and I am a co-worker of Dorian's. I drive for, I'm a transit operator for Muni out of the Potrero Yard. And the supervisor you spoke of, Cynthia Williams, is I have found to be, in my own dealings with, she's threatened me, and she's abused her power in that way regarding issues that had nothing to do with driving, my driving, or my employment with Muni. It had to do with a personal matter she was having with another supervisor. And I find that.
Okay, sir, I'm sorry to interrupt, but you're really not addressing the issue that's before us.
Okay, I'm sorry then. I thought the issue was the fact that he's speaking on behalf of one of the people that.
Well, this has to do, sir. This has to do with the specific recommendation that David Hill's name be forwarded to the Ethics Commission for violation of a certain section of the Sunshine Ordinance.
Okay.
Okay, and not to invalidate or
I understand.
or in any way disparage what you've been saying to us, but it's a separate issue, not before
I
us.
understand what you're saying. I got it. Then maybe this will clear things up. I have asked for other records from the MTA regarding inspection pamphlets on buses, inspection reports on buses for safety reasons, and they withhold those from me. So I've asked for other records regarding the equipment we use in doing our jobs, and they refuse them. And I don't know of any other transit agency or bus agency that does not let drivers see inspection reports on the vehicles they're operating. So that's about it. Thank you.
Thank you. Is there anybody else to order facts and evidence in support of the complainant?
Yeah, my name is Cynthia Carter. I, too, did have some issues with David Hill, who refused to help me on a situation. I was wrongfully terminated. He could have done something about it, did not. I'd like to add some names to the letter that Dorian wrote to you, Superintendents Sarita Britt and Wallace Johnson. They should be added to that letter as well. And I would, if you can let me know how I can file a complaint with you for what's happened to me. Mine is a long story, and we don't have enough time for you to hear it. So if you can let me know how I can come and get you guys, file my complaint with you guys so you can do something about it, I'd appreciate it. Thank you.
Thank you. Is there anyone else to offer facts and information in support of the complainant? Just a quick response to your question, ma'am. If you want to contact our administrator, Mr. Rustum, he will be glad to. He's the gentleman sitting at the table here. He can help you file your complaint. Thank you. Is the respondent present? Is there anybody to provide facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Mr. Rustum.
Cheney, the respondent had sent you a letter saying that he's out of town.
Okay. Matters with the task force. Member Johnson.
For those of you that were at the compliance committee meeting, I think you probably know that I really want this to go to the Ethics Commission. I just want to take this opportunity to, with all due respect to Mr. Threed, who I think is very professional in the light of criticism. I think he tries to provide us advice in a very professional manner. I think that this case got printed in the newspaper with disparaging remarks by the spokesperson for the city attorney who represented himself as a spokesperson. Luckily, the author of that article did not include the email that Mr. Dorsey presented, which, as a spokesperson for the city attorney, mocked and misrepresented our finding against a case which he had before us. And I think that the Ethics Commission, Mr. St. Croix, talking the way he did with this case, getting mixed up in it in the press, is very unethical. It's very unprofessional, and we're their client. But Mr. Maxwell, the MTA, two of his supervisors at the MTA came before us and stated that these, literally, the documents he was asking for did not exist. Not that they didn't know where they were or that they didn't know if they existed, but they did not exist. That Mr. Maxwell was terminated, that he did not have a right to see documents that they had not chosen for his Skelly hearing. And my first 4 years at work as a paralegal, I went to trial with a large law firm as in employment litigation cases, and I mean that would not be tolerated at all, and we should not tolerate it either. And even though they gave him the document, I find it even more outrageous that they gave it to him after they decided to allow him to keep his job, which I think makes it even more suspect. Now, I'm not sure that I agree with adding people that we didn't discuss before, even though there may be legitimate reason, I don't know, but we hadn't had that before us. Though I do still agree with the David Hill being responsible. As Ms. Chambers said to us at compliance, that she had to go through a lot to get the documents, and that should not be the case for somebody's personnel file. I mean, when it's their own file, she should have been easily able to find his entire file. I do have one question. I don't know if it's to the city attorney's office or to the chair or members who've been here longer. at compliance, we had said that we were going to send this, we wanted to send this to ethics for failure to comply with the order of determination. Is that 67.33?
No. The failure to provide the order of determination, the agent, if you read the order of determination, the decision and order of determination at the bottom, the sections violated were 67.25, 67.26, and 67.27 of the Sunshine Ordinance, and also California Public Records Act, Section 6254C. At the Compliance and Amendments Committee hearing, we determined that the records had been provided to, there was general, I think, compliance with the order of determination, and that there seemed to be a sincere effort on the part of the immediate respondents to comply. But as one of the respondents mentioned to us, she had a lot of problem getting the records, and we asked her who her immediate supervisor was, and I believe David Hill was the person she named. And it became clear to us during the Compliance and Amendments Committee hearing, this is my recollection, that Mr. Hill had violated 67.33 by failing to make sure that the people under his supervision were cognizant of the Sunshine requirements and cognizant of how to comply therewith. That's my recollection. Member Knebber, Member Washburn, Member Wolf.
So, I mean, just to be clear, this is two separate issues, and we would refer to ethics the failure to comply, and then adding on to that would be fine a violation of 6733 for David Hill.
No.
That is what Mr. Grossman and I recommended at compliance, that it was for failure to comply with the order of determination.
Okay. I stand corrected. Member Washburn?
I do distinctly remember that I think the evidence that led us to 67.33 for failure to instruct the MTA employees was Ms. Unos was the employee that was originally, it was her responsibility to get these documents. And when she appeared before us, she seemed absolutely clueless about the Sunshine Ordinance. She didn't make any effort to find these documents or say anything to Mr. Maxwell. She just let this matter slide for weeks and weeks. And so I think we reasoned that this department seemed to be poorly trained with regard to Sunshine, and it's incumbent on the supervisor to make sure that happens. So that was the reason for 67.33, which I strongly endorse that this is a basis for going to ethics. I don't recall that.
This is the same argument we had at compliance. This is the exact same. You guys wanted to send it to training, and I was very adamant that and Mr. Grossman got up and said that we didn't have to send it to ethics just for willful violation, for willful failure. We could send it to ethics for failure to comply with the order of determination. The fact that he got his documents is great, but the fact that they didn't give them to him until well after that is a violation that needs to be addressed. It was not remedied in a way that was, I mean, if Mr. Maxwell had lost his job, getting them 6 months later would not have helped him. It just so happened that he didn't. So this is the same argument we had at compliance, and you had originally wanted to send it to the Education, Outreach, and Training, and Mr. Grossman got up and suggested that we could send it to ethics for failure to comply with an order of determination.
Member Wolf?
I just want to point out a problem with our procedure at this point. We're dealing with a case that what we have in front of us is just the order of determination. And a lot of different discussion and outcomes resulted out of compliance and amendments, and we don't have any record of that for those members that were not at that committee meeting. And I find that to be a little difficult because we are now, those members on the Compliance and Amendments Committee are now having to recall what happened at that meeting. There's no written record of the compliance and amendments in that particular case, except maybe in the minutes. But I think that's what's making things a little bit difficult for me sitting here, because I know that there other members don't have a clue as to what we're talking about. But what I will say about this case is it was very obvious that Ms. Chambers knew nothing about Mr. Maxwell's case from the inception of the case, because she had not been assigned the case at that time. She had not either been working there or had been his supervisor. It had come under a different person because, and that person had left the department. By the same token, there was no mention of the inspector, and the inspector should have been brought forward. Unfortunately, we don't have the ability to make that person appear, but that person could have answered all the questions for the facts and the evidence that we needed. Be it as it may, Ms. Chambers, to me, I felt really didn't have a clue. She had nowhere to even look to find out where any of this information was. And the fact that she did continue digging around until she found them, I find to be somewhat commendable. The fact that they were found was commendable, okay? Because had she not been there, even at the end, Mr. Maxwell may not have gotten these documents. Now, I haven't heard anything to the contrary of that. I haven't heard anything to the contrary that she refused to look for these items or anything to that matter. What I've heard was that the items were not made available to her, which means that they were being held by somebody else. And the fact they miraculously showed up sometime later on because they weren't in the documents that she had been handling for him, that's what seemed really suspect to me about the entire system. And that's why we chose to focus on Mr. David Hill, because he's the one that oversees all of this, and that we decided to go after the supervisor of the supervisor, who is the department head, because he's the one who's supposed to know how Sunshine's supposed to work, and he's supposed to know what needs to be provided. And so if Ms. Chambers, as she testified, she said, I don't have any more documents to give, okay, and then finally showed up, and it sounded like somebody else gave her the documents, and she wasn't the one that was able to find them. So my point here is that I think it's totally appropriate, and for the other members who weren't there, that you hear now a different name. It's appropriate for Mr. Hill to be the focus of where we're pointing our ruling to here today. It's totally appropriate. He was the one in charge, and he was the one that was responsible for training, making sure Sunshine was being carried out properly.
Mr. Threet?
Through the chair, I recognize and realize this may not be popular advice tonight in light of the comments that have gone before. I have previously, in similar situations, given the same advice, and that advice is that when there is a complaint that has not named a particular individual and they have not been given the opportunity to respond to charges against them, that it raises significant due process concerns if they are then found in violation of the ordinance. I wasn't at the meeting. I don't know if Mr. Hill was there, if he's had an opportunity, but if the task force is considering finding Mr. Hill in violation of the ordinance, I believe it is advisable that he be given that opportunity prior to that finding.
Thank you, Mr. Threet. Mr. Rustum, was Mr. Hill notified of tonight's hearing?
Yes, Mr. Chair.
And did he give any kind of response as to whether he planned to attend?
The notification was sent out Friday. Monday afternoon, he sent me the email that I forwarded to you.
And could you repeat?
I believe
the
he
gist
said
of that
he was out of town and was not able to attend.
Okay, thank you. At this time, there being nobody representing the respondent, this time the complainant will have 3 minutes to make any concluding remarks. Mr. Maxwell?
As I said before, they think they're untouchable against the law. I mean, what is it? What does it take to get justice around here? It's adamantly that there's no support in finding these people in criminal behavior. I really feel that this matter should be referred to the State Attorney General's office because it is some criminal activity. It's some operators just lost their job because the SFMTA have fabricated or withheld pertinent documents that could have exonerated them. And the city attorney needs to look into that also. And it's just ridiculous. Where did Cindy get the files from? They came from somewhere. Somebody had to hide those files in the bushes somewhere for them to come out. Somebody had their hands in there. The emails been popping around. I looked at some of the emails. I put the emails on the light. Some of them came from Sean Ellsberg. Sean Ellsberg's name was on some of these emails. And who was Brenda Walker? Her name was on some of these emails. Somebody been playing games. It's my livelihood that they were playing games with, trying to put just for their passage of Proposition G, attacking me just because my views on Proposition G, just because they didn't even do anything to the other operator that had the coach that the email said they had. The driver was driving around with it. And it's sad that I'm being crucified. Somebody has to be accountable for withholding evidence against me that would have exonerated me, because the emails definitely said that I wasn't the driver that had that coach at the time that the photographs were taken. And it's sick to have to go through this months. It took about 5 months to get those documents. I lost wages, I lost holiday pay, and I lost the right to be able to go out and work overtime. Somebody has to pay, and somebody has to be accountable. If it's Nathan Ford, David Hill, whoever, somebody's going to be accountable for their actions. And this task force need to push this to the Ethics Commission, as well as the State Attorney General's office, as well as the State Department of Justice, because it's some fraudulent activity going on in the SFMTA, and it needs to be reviewed and discovered and put out there so the public can know what type of entity is running their bus system that they rely on a day-to-day basis to get them to and from work.
Thank you, sir. Matters back with the task force. Okay, Mr. Threed has raised the point about the respondent not being here, finding out just recently that this was being brought against him. And the question now becomes, do we want to move forward with this and refer it to ethics, or do we want to continue this for a month and give Mr. Hill a chance to respond to the allegations? Member Johnson, Member Coffin.
I would like to point out that one of the reasons why we chose Mr. Hill in this particular instance is because Mr. Maxwell's supervisor at the time of the incident was no longer his supervisor, and Ms. Chambers came on at that station at some time after the incident occurred. So the transition we had discussed that we would have probably sent Ms. Chambers' name forward if she had been the original supervisor. But since she stepped in the middle, we were holding her, the supervisor above her, accountable. And I also think that moving forward, so much time has passed, and this was clearly something that was well known to those supervisors because it's a termination issue.
Member Coffin.
As Mr. Wolf said, I'm one of the people who is mystified. I'm trying to pick it up from just reading the order of determination. But it does seem to me that if someone has allegations placed against them and they have not been given really ample opportunity to address them, that it's only fair, even though this has been going on for a long time, it seems to me it's only fair to give them another opportunity. He did say that he couldn't come this time, but I'm not sure how much time did you give him, Mr. Rustum?
Through the chair, the notification was sent out on Friday evening.
Friday, that's what I thought you said. So, I mean, I would encourage continuing it one more time and giving Mr. Hill an opportunity to defend himself, or whomever in this melange of names seems to be the appropriate party.
Member Johnson.
A question, I'm not sure who's the appropriate person to respond, but there is no question about the fact that we were told by respondents from the MTA that these documents did not exist, that Mr. Maxwell was not entitled to his entire personnel file. And out of nowhere, the inspector's report suddenly shows up. I am not going to listen to why that happened again, because it is one of the more outrageous things we've had in front of us. For them to tell us that it does not exist, this is very, very serious. And if the task force does not want to name David Hill, unfortunately for Ms. Chambers, I'm going to want to name Ms. Chambers, because there isn't anything that Mr. Hill could say that would change that those documents did exist and that we were told repeatedly that they did not. And I want to find somebody accountable for that. It is undeniable. It is undefendable. I was sitting right there when it was happening.
Member Wolf.
I think what also, in addition to just that they said that they didn't exist, was that my understanding for what Ms. Chambers' testimony was with regards to what documents would be available to Mr. Maxwell, it didn't sound like that any employee would have access to all the documents. It would be just whatever documents was in their file. It wouldn't be any documents that could exist outside the file. That could be public documents. So it's not just the admission of documents that didn't exist. It was the fact that they didn't even bother to look or to even say that documents would not be available. I think that, to me, is what strikes home. And on top of that, further, that they said that there were documents that didn't exist that ended up finding their way to Mr. Maxwell later. The last thing I would just say is that these documents weren't like in some deep storage archive. We're talking about within 1 year. So they had to have been in the office somewhere, and somebody knew about them. So, I maintain that that Mr. Hill, who is the department head, is responsible for this because he's responsible for knowing how Sunshine works and to disseminate that training or that information to all his employees, and that's what the ordinance calls for, specifically that there's in 6733 that it's the declaration of the department head to provide such information and make sure that they're doing the things right. And it didn't sound like Ms. Chambers was trained properly.
Member Knebber, Member Washburn, Member Costa.
Two things. Number one, I do feel uncomfortable with finding. This is consistent with the way I always felt. I think I've had this discussion with Member Wolf specifically about this before. I'm uncomfortable with finding a violation for Mr. Hill without him having due process. However, I do think, and including the way this is worded, I don't know if it's intended that way, I do think that this is a separable issue. I do think that we could find the department in violation. We can refer the department to the Ethics Commission for failure to comply in a timely manner, and then Mr. Hill, as a separate matter, could be charged. That part can be continued to have him answer for violation of 6733, as for not informing his department of the proper procedures under Sunshine.
Member Washburn, Member Costa.
That's exactly what I was going to suggest. I think we have the immediate problem that's so outrageous with the staff saying these things didn't exist and Mr. Maxwell didn't have a right to them. So I would support separating the two issues. I don't know who to name for that one exactly. That's the thing. It's just the department. But I think from the testimony we've heard tonight from Ms. Carter, for example, and Mr. Coughlin, it looks like they're just confirming what we were starting to suspect. There's a far bigger problem than what Mr. Maxwell brought to us, and so I think I too am uncomfortable sending this on to ethics without hearing from Mr. Hill. I'd like to have him here so we can talk to him and ask him questions. And I think I would support having separating the specific issue from Mr. Maxwell and the more general issue with Mr. Hill in 67.33.
Member Costa.
I agree with the last two speakers.
Excuse me, Member Costa.
Oh, Costa, sorry.
And then Member Coughlin.
I was largely going to say the same thing. So, Member Coughlin, go ahead.
Member Coughlin.
So I agree with Member Costa, Member Washburn, and Member Knieber. I wasn't here when this was heard, and I was indeed somewhat mystified, but it did sound, when I read the order of determination, but it did sound obviously as though the department was completely out in left field when it came to giving Mr. Maxwell the documents he was entitled to. So I think that severing this is a good idea, and then we can hear from Mr. Hill or whomever the responsible party or parties is.
Member Wolf.
While I appreciate the sentiment about separating things, we can never send a whole agency or department to ethics. It's not the purpose of the Sunshine Ordinance. Ordinance doesn't provide for that. It provides for people. People take the oath. People are the ones that follow the ordinance. Departments don't. And that's why we need to identify who is ultimately responsible for this. And again, the department head is constantly repeated in the Sunshine Ordinance. I'm sorry Mr. Hill couldn't be here today. He was notified. If he thought this was really important, he would have made it his business to be here. And that's the way I feel about it. This case has been going on for some time. At the same token, Ms. Chambers couldn't answer a whole lot of questions because she had no knowledge. But I'm sure Mr. Hill did. And the fact that she actually mentioned him by name as being a responsible party for this, I think, is significant.
Member Costa, Member Knebber.
I agree with Member Wolf, and that was another piece of what I was going to just say. However, it seems to me like that as a matter of due process, our hands are sort of tied at this moment. While I agree that we need to find, so it seems like there are two sort of separate issues. One is that we know who seems to be responsible, and we want to hold that person responsible. But as a matter of due process, at this moment, we can't. Yet we also want to enact some sort of timely action. I agree. I hear I hear your thoughts about, or your feelings about not wanting to let this go without acting on it, right now. And so it seems like I agree that holding an agency in violation is not going to do anything, and that seems like it should inform our process for the future more than anything else in terms of trying to identify an individual from the beginning when finding orders of determination. But for right now, it seems like our choice is, if we want this to really be as effective as it should be, find the agency in violation for now and continue the matter further examining Mr. Hill, or do nothing now and continue the matter examining Mr. Hill. Because if we find Mr. Hill in violation right now, it seems like it may run into due process issues down the road. And I think that we don't want that. We want the most we want the most teeth that this can have, because he seems to be the responsible party. So,
Member Knebber.
Yeah, I the only way, if people are uncomfortable, the only way I can see this is either holding Ms. Chambers accountable, or we have to give 10 days. And this was reported to Mr. Hill on Friday per our clerk. That's not 10 days.
Where does it say 10 days? There's nothing in the ordinance that
Member
says...
Wolf?
There's nothing in the ordinance that says we're required to give notice to somebody 10 days. We don't have subpoena power. We can't ask anybody to show up. It's the matter. It is what it is. The fact that we did not provide more time for him, I think, is unfortunate. But be it as it may, what before us is the order, what the ruling that we found. They are in violation of something. Okay, and the question is who's the responsible party? Okay, if Mr. Hill is, and the other question is due process. The ordinance doesn't specify due process. The due process is based upon what we determine that process to be in what we're doing here today. I have not read anywhere in the ordinance that talks about how a process for complaints and hearings and what have you is how it's supposed to go. Okay, that's why we have rules and bylaws and the way things run. So, as far as I can see in our bylaws, there's no specificity for that. And as far as I'm concerned, it's hard for me to put it on Ms. Chambers because she came after the fact. We could do it because she's there now, but it has to be somebody. Who it goes to, ethics, attorney general, district attorney, I'm okay with all of that. But we have to do it to a person.
Member Chan, Member Johnson, Member Washburn, Member Coughlin. Oh, okay. Member Johnson, Member Coughlin, Member Washburn.
So I don't mind separating it out, but it is two separate issues. They failed to respond, and they provided us with an improper justification for withholding the documents. Number one, they didn't give us the documents, and number two, they said that he wasn't entitled to them because they didn't choose them for the Skelly hearing. I mean, they might as well have just said they were picking and choosing what served them best. Someone needs to be held responsible for failure to respond. Responding at the compliance committee after Mr. Maxwell has threatened litigation, which the district attorney's office did as well, after he nearly lost his job. For Member Costa, you will come to see that is a dance that is done here regularly. And for them to just be able to walk up and pass it all around and say, I don't know, and the MTA, when the department head signs something that they've taken the training of sunshine. So if you want to wait for Mr. Hill for due process for 67.33, I can understand that, because I agree with Member Wolf that there's no rule about waiting 10 days, but if the members feel more comfortable doing that. But that does not address why Mr. Maxwell's direct superiors withheld this document from him and even tried to convince him that it didn't exist, even though he was there when the inspector was on the bus. This is very, very serious. This is somebody's job. I cannot just let this go. And if it's Ms. Chambers and Ms. Uno who are the ones who represented it instead of just the MTA, so be it. I think it's wonderful that Ms. Chambers did it, went out of her way for Mr. Maxwell. But that does not change the fact that they withheld documents that are very serious. How would you like it? If somebody you wouldn't like it because they withheld something from the Library Commission. This is how you get a job. I cannot understand how you would pass that off to training. That is criminal behavior to me. And maybe that's pushing it for some of you. But they literally stood in front of us and said he was not entitled to them because they didn't want him to have it for the Skelly hearing. You can look it up. You can hear it. And for us to not, for us to not make a determination that those kinds of documents are what need to be turned over in a timely manner is outrageous.
Member Cawthon, Member Washburn.
I think we definitely should pass a resolution making it very clear that we don't agree with the way they conducted themselves. When it goes to ethics, they're going to have to send a responsible party. But I think that due process is kind of the basis of the American legal system and way of life. It seems to me that if we're going to accuse someone of something, I mean, we're assuming that Mr. Hill is the responsible party. I think we should definitely hear from Mr. Hill as to why he did what he did or didn't do what he didn't do, and then we can move forward with the Mr. Hill's condemnation.
Member Washburn.
I suggest, and first of all, I applaud Member Johnson's passion and agree with her. And I think what I suggest we do is that we name Ms. Uno in a referral to ethics. She was the person who first spoke to us. She was the initial respondent who spoke to us and said that, told us that these things weren't in his Skelly file, and she's also the one that didn't reply to him for weeks and weeks and weeks. She's also the person who would come up to Ms. Chambers at compliance and whisper to her. She was kind of coaching her. So she seemed like a nice enough person, but she was the person who was the respondent initially. We can put a face to this action, and she was there all along. Ms. Chambers wasn't. So I suggest we name Ms. Uno and send this to ethics and then continue 67.33 till next time. The bigger matter.
Member Wolf.
It's interesting that you bring that up, Member Washburn. I'd be interested in doing that, and then I'd like to see if ethics does the right thing and actually listen to the case and research it and say, you know what, there is a violation here, but you're choosing the wrong person, and maybe send it back to us and say this is the person who we found to be really in violation. I'd love to see that. I doubt we'll ever get that, but in a perfect world, that maybe not in an imperfect world, that would be the case. But I'm open to doing that. It has to be a person. We can't send the agency there.
Is there a motion? Member Washburn.
I move to forward this matter to ethics, naming Ms. Uno, and for willful failure to comply with the order of determination, 67.25 for failure to respond, 67.26 for not keeping withholding to a minimum, and 67.27 for failing to provide justification for withholding.
Is there a second?
And the California Public Records Act, Section 6254C.
A second.
Moved and seconded. Is there discussion? Member Knebber.
Does that include continuing the 6733 against Director of Bus Operations David Hill, or is that include? Okay.
I believe that will be separate.
It does or doesn't include it?
Does not include it. The continuance motion will be separate. Member Costa.
I guess as a new member, I understand the discussion here, but I feel like what I'm lacking is I would need a little bit of confirmation, I guess, that we really feel confident that this is the person that is as responsible before voting affirmatively for this measure, because I think that I want the person who is responsible to be held responsible, and I don't want to just sort of throw this out there as an experiment. I think that, so if anybody can speak to that a little bit further.
Member Johnson.
Mr. Maxwell, your original request for the documents was to who?
Cynthia Chambers and Uno.
That was your original request? Yeah. Thank you. Thank you. One more thing. I don't know how else. I mean, a reasonable person requests their employment records from their supervisor. And when he did not receive them, they came in here and represented that certain documents did not exist, even though Mr. Maxwell said that he repeatedly said that an inspector had inspected his bus, and they insisted that the inspection report did not exist in those exact words. And if you want to hold somebody accountable, I mean, that's who he asked for the records. And to push it off on somebody else is to create a situation where you're passing it all around. I mean, if you're going to ask somebody, they didn't even respond to him right away. So I think that establishes pretty clearly that his direct supervisors were the ones that were responsible for finding these documents, especially because he has a right to his employment records. And then suddenly the inspection report was before us.
Further discussion. At this time, we will take public comment on this item.
Hi, Kimo Crossman. I think you've come down with a decent approach. I just saw the letter that Mr. Garza got from Ethics 2 days ago, and the issues that they rose in dismissing the referral you sent to Ethics. A couple of them had to do with due process. Said somebody hadn't been in a meeting when you made some determination, so they're going to waive it because that person wasn't at the meeting or hadn't been notified. Another prong that they used to dismiss it had to do with that you didn't actually find, and this is under the current regulations, which of course they may be changing for Sunshine, but under current regulations, they said, well, you didn't find a violation of 6734, willful failure. So without that in your referral, we're not going to move forward because you didn't officially find willful failure 6734. So I'm just tossing that out. I think you should continue the item for Hill and give him one chance to show up, with plenty of time. If he doesn't show up, then, find him in failure. But I think even on this particular item, if you want Ethics to enforce it under their current regulations, I think you have to add 6734 onto it. As Mr. Wolf said, you have to find individuals. You can't find a department. And they have to be managerial employees.
Thank you. Is there further public comment on this item? Sir, you've already spoken as a party, as
I can't. I
no,
can't
sir,
speak as a public person.
That's correct. You provided facts and evidence, so you're part of the party in interest.
Good evening. David Pilpel, former member of the task force. Nice to be back. I was here on a different item, but I heard part of the discussion. I believe that the only action that you can take on this agenda item is to make a referral of Mr. Hill. I don't believe you can substitute a name and send someone else at this meeting with the agenda item as it's scoped. I didn't hear enough of the hearing, but it seems like the employee's immediate supervisor, whoever it was at the time, may well be the appropriate person and should be notified. Ultimately, the department head here is Nat Ford, and he's the person responsible. Mr. Hill is a mid-level manager, and if you want to get Nat Ford on something, I suggest doing it soon because he may not be here much longer. In any event, I have not read the file, but I think it's worth pointing out that an employee's rights to information may be different in certain contexts than a member of the general public. They should not have less access to information. They may have more access to information, but it depends on the circumstances. So I hope that's helpful, and I'm here on a different item as well. Nice to be back. Thank you.
Thank you. Is there further public comment on this item?
Thomas Piccirillo. That was a very astute observation. Your agenda item says that you're going to deal with Mr. Hill, but now you want to apply the order of determination to somebody else. I don't think you can do that. But I am, as a retired attorney, I'm troubled by the statement that due process is what you say it is. That's not the case. You're an administrative agent, a body, and due process is what the courts say due process is, not what determinations that you make. If you look at the order of determination that's in your packet agenda, there's no mention of Mr. Hill. Again, the problem there is your minutes, your lack of minutes. There was a finding, a subsequent finding to amend to Mr. Hill. Well, the public doesn't have that. If you got a order of determination naming Mr. Hill, the public does not have that in this booklet. So that's another problem you have. Let me finish, though. Your order of determination doesn't make a mention of Mr. Hill. My recollection, without the minutes, is that there was an amendment naming Mr. Hill because you established that Ms. Chambers was a victim in this case, as well as Mr. Maxwell. But again, there's no minutes. So we're all speculating in the transaction of this entire case. It's frustrating. It's frustrating to try to remember what this task force did or what I did 2 months ago regarding Mr. Maxwell and MTA. So, again, the problem is minute taking. You and the public need to keep current with the minutes. Both contemporaneously as well as substantively. The minutes should reflect the history of this case. The packet doesn't mention Mr. Hill. Your agenda mentions Mr. Hill. I can understand why Mr. Hill is not here tonight. Thank you.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Member Kneber.
Again, I don't have a problem with the way that this is worded. I don't think it was the intent, but the way it's worded, I think it can be separated between a complaint against David Hill for 6733 and then separate out, and that the matter be forwarded to the Ethics Commission, which I could take to be referring to number 10059 as a whole for that order of determination. So I have no problem with that. These two separate.
Member Wolf.
Okay. I want to take member of the public, Mr. Piccirillo's statement. I want to respect that, and I agree in part. The documents are supplied for an item are a matter of reference. The action item is what you see as the listing on pages 1 through 3. That's what we're working off of. The documents that are contained within pertaining to each item are reference materials for that particular item. Now, the fact that the compliance and now the order of determination comes before the Compliance and Amendments Committee. Compliance and Amendments Committee makes a decision based upon what happens there, and then makes a recommendation. That's what we're doing right here, is working with a recommendation from the Compliance and Amendments Committee. Now, the minutes of the Compliance and Amendments Committee is contained in the agenda. It's on page 182. Now, what's interesting there is that there's a third person that's named. And that third person is, in fact, the executive director and the CEO, Nathaniel P. Ford Sr. And Mr. Hill's name is not in the minutes there. So I'm a little confused as to how. Now, in addition, I'm sorry, my mistake, because there is a replacement. It does say Member Nee, seconded by Member Wolf, motion to replace Mr. Ford with David Hill, the director of bus operations. So I stand correct myself. I don't think it's incorrect to name Mr. Hill. I understand we talked about doing Mr. Ford, but he's so high up on the ladder, it's like he wouldn't have any knowledge of any of this. It would be symbolic. I'm okay with doing things symbolically. I think that's perfectly okay. Despite when the agency is being brought forward, you want to name who's the head of the agency is responsible. But I think also it's the people that are actually doing the work, the person who actually had control over making a decision, and that's, I think, makes it hit home a little bit more. Nobody may know who Mr. David Hill is. That everybody knows who Mr. Nathaniel P. Ford Sr. is, and so that if we're looking to sensationalize it in some way, I'll leave that up to members to determine who exactly they want to point finger at. But for me, it's more important to get to the function, the functional process, and where it's breaking down. And I think we're correct in putting our focus onto Mr. Hill at this point. He's a managerial employee. It fits within the. It fits within 6733, and it does fit in with 6734 too. Okay. If you feel uncomfortable, I agree with what some people are talking about. You can't send it to ethics on just without 6734. You want to wait and you want to have Mr. Hill show up so you can do it then in front of him. That's fine. I'm okay with that. But at some point or another, we're at that place. We're at that juncture.
Well, we're not at that juncture yet. That's going to be a separate motion. Member Washburn, Member Cawthon, Member Johnson.
I agree with Mr. Crossman's suggestion about 67.34. If ethics is going to do nothing because that's not there, then we need to put it there. And if ever a case warranted 67.34, this one does. So we can wait and see what Mr. Hill has to say for himself before entertaining adding that to any matter for him. So, but I would like to amend my original motion to incorporate 67.34, willful failure.
Second accepts. Who seconded the motion?
Is that applying to Ms. Chambers and Ms. Uno?
Right now, we just are naming Ms. Uno in the matter we're sending
yes.
to ethics.
Yes.
Second accepts. Member Cawthon?
I just want to reiterate the problem I'm having with due process. Since I didn't know about any of this, I can only judge from what you people are telling me, and it's very confusing. It's Ms. Chambers, Ms. Uno, Mr. Ford, Mr. Hill. I really don't think that we should. I have seen nothing to indicate that Mr. Hill was involved in this. We're just assuming that. So I think that if we don't want to send it to Mr. Ford as head of the agency, who will get it to the right person, I think that we should ask Mr. Hill to. We can send it to.
Okay, the motion on Mr. Hill is not yet before us.
It's separated right now.
Right, I'm saying
separate motion.
What I'm saying is I'm okay with sending it to ethics, naming
Ms. Uno,
Ms. Chambers, and Ms. Uno. Wasn't that your motion?
No, it's just Ms. Uno.
Yeah,
just Ms. Uno.
Just okay, but I do think if we want to follow up with Mr. Hill, we need to hear from Mr. Hill.
Member Johnson.
Compliance and amendments Mr. Grossman said we did not have, okay. We're working on Ethics Commission regulations. The Ethics Commission has to hear orders of determination that the Sunshine Task Force sends to it, even if it's not for willful violation. So we do not have to find willful violation. We're working on those Ethics Commission regulations right now. That's what we're working on, that we're going to send them orders of determination. And Mr. Grossman suggested that we could send to ethics something for failure to comply with an order of determination. But I wanted to address Mr. Pilpel's comment about the agenda item. I think our items address the order of determination as well as Mr. Hill, but the Mr. Hill, the separation of them is two separate things. One of them did not turn over willful. I'm willing to add 34 because they willfully did not turn over the documents. The idea that Mr. Hill should have trained them better is separate from the fact that we really have in front of us unrefutable evidence that the documents existed, that they did not tell us that Ms. Uno suggested that the documents did not exist and that he was not entitled to them, both of which are violations of the Sunshine Ordinance, whether he got them at the very last minute or not. They violated the Sunshine Ordinance by not providing documents that he should have been provided, Ms. Uno.
Member Kneber, Member Washburn.
Can I ask one more question?
Member
through the chair,
Member Johnson.
or maybe to
Member Johnson.
Mr. Hill, when he said he could not attend in the email, did he suggest that he would send somebody in his place? Did he ask for a continuance? What was his?
Mr. Chair, if I can have the email,
Mr.
I'll
Clerk.
read it for him.
I'm not sure I have the email with me.
Through the chair, Mr. David Hill says, I am sorry, but I'm on vacation out of the state of California. I will return on Monday, March 28th.
I just think that they're two separate issues, and there is not a question, and there is not an excuse. There is no longer. Are you going to let them go back now and say, oh, we didn't know? They represented the documents did not exist. If Mr. Maxwell had not been persistent for 5 months, we would have just gone on thinking the documents did not exist. What constitutes a violation if that does not?
Member Washburn.
I no longer have anything to say, Ms. Johnson.
Okay, I have a question for Mr. Threet. Mr. Threet. In sentiment and in principle, I agree with the thrust of the current motion that's before us. However, I would like to hear you address the point that Mr. Pilpel raised, which is this is not on the agenda unless you consider the attachment to the agenda as part of the as part of the item. And I'm just curious to know, do you think that the motion is proper at this time?
Chair Ghaני and members, the description, if the intention was to forward the matter for a violation of the order of determination, the agenda description is less than a model of clarity on that matter. The agenda description should be so clear that would it inform someone who had an interest in the matter what action could be taken. It's certainly plausible for a knowledgeable person to read this and say, well, it's two different things that could happen. One is a referral of Mr. Hill, and the other is that the entire matter be forwarded for failure to comply with the order of determination. But it's not so clear that you know that if you're not that informed person. So I think that Mr. Pilpel's point is well taken.
Thank you. Member Washburn.
Well, I'm wondering, though, it says that the Compliance and Amendments Committee has referred this matter to the task force with a recommendation that MTA director, blah, and so forth. So don't we routinely, the Compliance and Amendments, send matters back to the task force, and then it's up to the task force to take some action, which is not always known in advance. So here we wanted this to come back to the task force. This was what we were recommending based on our hearing at that time. So now we're back here, and the task force is acting on this matter after having another hearing. So
That's true.
I don't know
well,
why.
That's true, but the recommendation from the Compliance and Amendments Committee specifically named Mr. Hill. It did not name anybody else.
That's true.
And again, I agree wholeheartedly with the sentiment and the principle of this motion, and I think it should go forward. I'm just not sure that this is the appropriate time to do it because of the rules of procedure and because of the way the matter appears on the agenda. Member Wolf.
I have a little problem with that that interpretation. Committee doesn't have the force of the rule. The entire task force has the force of the rule. The committees provide recommendations back. If the task force disagrees with the committee, it could do one of two things. It can overrule the committee, and we're here in public, and we're discussing the matter. And if the recommendation that the Compliance Amendments Committee, in the wisdom of the entire task force, and having further public comment and further discussion about it, finds that the Compliance Amendments overlooked something or did something incorrectly, it can make that correction. It has the free will to do that because we're in public session. And people who are here and can make comment if they think that we're wrong. I think that that's an important factor here to be made. Whether we think it's Mr. Hill or we think it's Ms. Uno, we think whatever it is, all these people are part and party to this issue. The agenda item as it reads, as far as 6733 for failure to instruct MTA employees, that to me was blatantly clear at the compliance amendments that they didn't know a lot of things, which means they weren't instructed properly. Who's the person responsible for instruction? Their supervisor, the person who's supposed to sign the declaration. Now, what I do have some disagreement with is you cannot send 6733 to the Ethics Commission because the ordinance doesn't provide for that. The ordinance only provides for 6734 to be sent to the Ethics Commission. And the only other time that the Ethics Commission can hear something is if it hasn't been heard out by a court or somebody outside that the complainant can bring it straight to the Ethics Commission. Otherwise, it can only be referred to the district attorney or the attorney general on matters of like 6721 documents.
Member Johnson.
Then what are the regulations about our orders of determination for? Why are we drafting regulations about our orders of determination if our only thing is willful violation?
Right. It's because they don't have any procedures on how to even enforce those.
So are you saying that if you two things? I agree with Member Wolf that I agree with both Member Wolf and Mr. Pilpel, and that it could have been written more appropriately. It could have been written in a more clear meaning. But the meaning of it is that we're going to act on this order of determination. Now, the recommendation is that we act on Mr. Hill, but we're acting on the order of determination, not only on, we're acting on the lack of compliance. But of course, that's up to the chair. I can see both arguments. But the reality then is if we can only send it for willful violation and we can't act on it now, it means that Anybody could just stand up here and keep us going, holding the document for months and never have anything happen to them. You know, they're never going to get, I mean, there's two violations. There's a violation of training, but there's also, and this is what I was trying to say at compliance, there is a violation that they withheld a document, that they didn't give us proper justification for withholding it. They were not, he was entitled to see his entire personnel file, which they kept arguing with us that he was not entitled to see. And we've determined that that is not the case. And then they said that the document didn't exist, and suddenly at the last minute after Mr. Maxwell had threatened litigation, it appeared. And I mean, that is a serious violation. That is what the Sunshine Ordinance is for. It's not just for journalists to get information. I mean, this is very, very serious. And whether or not you bring Mr. Hill before you, I mean, I don't mind that you want to give him due process. I understand that. But we still need to address this idea that you cannot just withhold documents until they're no longer meaningful, until they're no longer helpful, until you've already corrected what you see as wrong by this person like Mr. Maxwell, who's determined to hold you accountable for things that you need to do. And to take it so lightly it's very serious.
Member Knebber, Member Chan.
This is going back a little bit, and I think we're going in circles here, but I think that there's a little bit of a confusion about what we believe and what is powerful for the Ethics Commission. I think I agree with most people here that it does not need to be a willful failure to go to the Ethics Commission. But the point was made that the Ethics Commission have said that they're not going to follow up on anything that isn't that way. Those are two different points, and I want to make that point clear. We have a difference of agreement, of course, as we do about a lot of the things with the Ethics Commission. And that difference of agreement is, one of many is that they said if we don't find willful violation, they don't think that it is valid. That's the point of contention. It is not whether we think it needs to be or whether we agree with them, but that's the point of contention.
Member Chan.
I think this has happened before. The beginning when I was in the task force, and I guess the task force made some recommendations, and I believe it's a willful violation, but again and again, department it's a game that they play, and without us doing anything, I think the public has no way to get these information, and it's probably a ritual for these departments to do it again and again and again, and play these games with people's lives and their livelihood, and it's very circumlocutory. It's like a circle, and people will still complain, come back, and we can't do anything about it. And I think it should stop right now, and we should make this good decision for the public.
Member Johnson.
I don't know if this is appropriate in light of we have to determine whether or not it was properly placed on the agenda. But I would just like to definitely make sure there are two separate rulings, because I'm not sure that you can find a willful violation of failure to train. How are you going to prove that that was willful when you have right in front of you the fact that they did not turn over these documents? To have people repeatedly, they didn't come in here once, they didn't come in here twice, they came in here repeatedly and said the documents didn't exist and then turned them over. So I just want to make sure that we have two separate rulings about it. And there is no reasoning that is going to change the fact that the documents appeared after they told us they didn't exist. That there's no reasoning that's going to make that better.
Member Wolf.
Okay, so I agree about the circuitous kind of thing that's happening here. I'm going to try to make it clear as to where the beginning and the end is, okay? for willful failure under 6734, it's the willful failure of any elected official, department head, or other managerial employee to discharge any duties imposed by the Sunshine Ordinance, the Brown Act, and/or the Public Records Act shall be deemed official misconduct. There's your answer for that. Okay? On the points for the documents, it goes back to, as I keep repeating, 6721E. Okay? If they don't produce the documents, we find an order of determination. They don't produce the documents after 5 days after that. We have the ability to send it not to ethics, but to only the Attorney General or the District Attorney or both. That's it. That's the beginning and the end. Those are the only two areas with regards to enforcement that we have in the ordinance. Those are the only two avenues, I should say. There's no other avenues for enforcement other than that. The only other avenues for enforcement is on the complainant to be able to take it to court. And then if something doesn't happen with regards to that process, then the complainant can bring it to ethics directly. I've been reading this backwards and forwards to make sure I get it clear, because we end up in these places a lot. And so if we can't send the public document portion to ethics, they don't hear items on that matter. They hear only items of willful failure. Okay, now you can say there was willful failure not to produce the items. Okay, that you could do that. Okay, because 6734 is all encompassing for all parts of the Sunshine Ordinance. But you have to find 6734 in order to get it to ethics. So that, I don't know, maybe I think whenever we make these determinations and they're based upon the disclosure or the production of public documents, and they're either withheld or what have you, and we find in violation of whatever other violations, that you have to also add whatever the functional enforcement section is part of the item. So whatever we do, I think from now on, it has to include, it's all these things and 6721E or 6734.
6734 is part of the motion, as a matter of fact. The maker of the motion amended, the second accepted, so it is part of the motion right now. Mr. Threet.
Through the chair, I just want to add one additional bit of information. If you look under 67.30C of the ordinance, about, 5-6 lines in, it says the task force shall make referrals to a municipal office with enforcement power under this ordinance or under the California Public Records Act and Brown Act whenever it concludes that any person has violated any provision of this ordinance or the acts. So that could both be read as a little more flexible, and it could be read as simply mirroring the other two provisions, but it's unclear.
Thank you.
Very good. Thank you for that.
Again, I totally agree with the thrust of the motion, but I think my own feeling on this, just from a strictly procedural standpoint, is better safe than sorry. We may well be violating the ordinance by passing the motion that's before us, and somebody could overturn it on that basis. Somebody could actually take us to the Ethics Commission and say, they passed this motion, it was not on the agenda. The agenda item here is very specific. It mentions Mr. Hill, period. It does not mention anybody else, not Ms. Chambers, not Ms. Uno, not Mr. Ford. Mr. Hill, that is the item that's on the agenda. And I'm, just for that reason, if we're going to vote on it, I will vote no. I would strongly recommend continuing this particular item until next month, and it could be properly.
State how it would be agendized if we continue it? Can you give you'd add the motion we have now on to what it says?
Well, yeah. What we could do it. We could make it. A single item or or a double item under the same agenda, since both of them refer to the single complaint, item 10059. Okay, it could be referral to the Ethics Commission, or notice of motion to refer to the Ethics Commission violation on the part of Ms. Uno, who's Rumi Uno, for failure to comply with order of determination. And then also let's say the task force has I'm trying to think how we're going to word this, so please bear with me. The task force determined at its last regular meeting on March 22nd, 2011, to consider referral to the Ethics Commission in the matter of order of determination 10059, willful violation on the part of Rumi Uno of the San Francisco Municipal Transportation Agency, 4 violations of willful violations of sections, Sunshine Ordinance sections 67.25 for failure to respond, 67.26 for not keeping withholding to a minimum, and 67.27 for failing to provide justification for withholding, and California Public Records Act 6254C, because the requester was asking for his own file and therefore disclosure to him could not have invaded his personal privacy. And the compliance and amendments, and then we repeat what is in the agenda item now. The compliance and amendments committee has referred, etc. We could do it an A and a B, or we could just make it a single agenda item, but with both of them on there. Member Wolf.
I would just add that we have included 6734. I would just also think about the other areas, 6721E and 6730C, if any of those apply, just to as an umbrella, because that's where we're provided the enforcement, the referral authority for enforcement.
Okay.
So I would just suggest that too. I was going to say I think that's a correct way, the correct way to put it. Otherwise, I was going to suggest that we reconsider the whole item, bring it back so we can make the proper citations of the ordinance. It won't change the outcome of what has happened thus far, but it will provide at least us more clarity, more discussion about exactly which sections and which people need to be focused on.
Member Coughlin? Okay.
And that's to continue it to the next.
Well, my suggestion was to reconsider it. So we would vote to reconsider it. We would bring it back to the table before us just before the vote. So it would be as if it was a live item again.
You mean bring it back tonight?
No, not tonight. Can't bring it back tonight.
Okay.
I have to bring it. I'd have to make the announcement for it today. It would have to be put on the agenda. We'd have to vote for reconsideration.
Okay.
Have a majority, and then at the time that we pass that, it would then be before us as if we hadn't taken a vote on it yet.
Okay.
And we can continue.
Member Cawthon?
I just wanted to clarify, we are sort of getting circuitous, as Mr. Wolf suggested. Are we going to hear from Mr. Hill? Are we going to continue this? It seems to me that's the only appropriate way. If we are mentioning Ms. Uno, I think we can send that part of it forward, even though I don't know if she clarifies as a managerial employee, which 67.34 applies to.
Okay.
So my question is, I'm unclear on the motion.
Okay. Well, first of all, on the motion itself that's before us deals only with Rumi Uno, all right? So, without objection, the chair will declare that on the advice of counsel, namely Mr. Threed, this matter is for procedural reasons and in order to comply with the Sunshine Ordinance and the Brown Act. This matter is continued until our next regular meeting, April 26, 2011. Without objection? Done.
But with apologies to Mr. Maxwell.
With apologies to Mr. Maxwell, we don't like to delay this matter. Justice delayed is indeed justice denied, but we feel that the course we're taking will be procedurally the strongest and the most airtight. And we think that in the long run, this will help you. The chair will entertain now a motion to continue the referral to the Ethics Commission on David Hill. Is there such a motion?
So move.
Is there a second? Discussion. Is there public comment on the matter on the motion to continue? Seeing none, public comment is closed. Roll call, please.
On the motion, Member Cawthon? Aye. Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber? Knebber, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 9 ayes. Motion passes.
Thank you. Before we go on to the next item, the chair will declare a 5-minute recess. We are back in session. Mr. Clerk, could you read item 10, please?
Yes, Mr. Chair, the Compliance and Amendments Committee has referred file number 10074 William J. Clark and Robert J. Clark against the Arts Commission back to the task force with the recommendation that it be referred to the Ethics Commission for non-compliance with the order of determination.
Okay. Is the complainant present? Thank you for coming, sir. You have 5 minutes if you wish to speak.
Good afternoon. Good evening. I'm William Clark, by the way, just to make you all aware. Since the meeting at the Compliance Committee, I still haven't received any explanation from the Art Commission regarding this, the main substance of my complaint, which was how they determine this 5% supervision and management charge. And I just want to remind you that in fact, it's not 5% of the salaries of the two individuals, but it's actually 5% of 110% of their salaries and benefits added together. And that's the substance of what one of the things we want to find out is why are we being charged 5% of 110% of their salaries and benefits. Since I filed the complaint, I found out that the management team consisted of Luis Cancel, the Director of Cultural Affairs, Jill Menton, the Director of Programs, Mr. Tun, who is the accountant, and Mr. San Wang, who is the Director of Grants. And the specific meeting that took place where this supervision charge was imposed upon us, only 3 members were present. That was Mr. Cancel, Ms. Menton, and the Art Commission's accountant, Mr. Hun. And so what I wanted to find out is how they decided that they were going to charge us 5% of the time that they used over the fiscal year to basically give themselves $1,000 above what their salaries and benefits were, because in their proposal they actually gave themselves more money than what the total of what 5% of their salaries and benefits were, which was additional $1,000. And so the only people present were Mr. Cancel and Menton and Hood. So I asked Mr. I pointed out to you that we wanted Mr. Cancel to explain this to us, and I felt that I would, since they said they had no records, I felt that a verbal explanation would be fine, because there were only 3 people there, and I wanted to know how they voted, and the 2 of the 3 people were the ones who got this money that was given to them. So obviously they voted for themselves to be given additional funds, more than the 5%. So what I'm saying is that I believe that I'm still entitled to finding out from one of these 3 members, in particular, Mr. Cancel or Ms. Montan, how they determined what that 5%. How they determined that 5% of their time and effort was used on the Street Arts program during the 2009-10 fiscal year. And the only thing I got from the Art Commission was an email from Mr. Tun, the accountant, which was brought up at the last hearing, stating that he thought the 5% was a reasonably liberal charge for the amount of effort and time Mr. Cancel, Ms. Menton spent on the Street Arts program during the 2009-10 fiscal year. It's in your files. So what I said is, what I asserted was, well, he either is just making that statement to make us feel bad, or he has some records or information that he could produce to support his assertion that the 5% is a reasonably liberal charge, and that it should have been more than 5%. So I brought that up at the compliance hearing, that I felt that it would have been helpful for him to present either the records to support his claim that it was reasonably liberal to charge us 5% of their salaries and benefits, or to admit that that was just a statement off the top of his head that he was just making. So my point is that I think you should proceed with this as the committee recommends, and perhaps at some point in time I can get a verbal explanation as to how this 5% was determined, and I would ask that you would do that. Thank you. I'm a little tired after that hearing, I know, so my mind is a little strange here, so bear with me too. Okay, thank you very much.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Thank you for coming, sir. You have 5 minutes.
I'm also a little tired. I'm Julio Matos, representing the Arts Commission and Streets Artist Program, Director Howard Lazar. As a representative, I was asked to convey to you the following information relating to this case. We thank you for your order of determination regarding case number 10074, issued on February 28, 2011. In its findings of the Arts Commission violation, the order discussed an Arts Commission supervision charge against the Street Artist Program based on 5% of the time spent by both the Director of Cultural Affairs and the Director of Programs in supervising the Streets Artist Program. The order cited the Arts Commission in violation of 67.22 for not providing oral information on how the 5% was figured, how the 5% figure was determined. The Arts Commission was ordered to release all relevant requested information within 5 days of the issuance of this order and appeared before the Compliance and Amendments Committee on March 8th, 2011. Prior to receiving the order, the Arts Commission staff continued on search for any documents that would be relevant to the clerk's request. On March 2nd, the Arts Commission released all relevant requested information when it forwarded to William and Robert Clark copies of the documents, which included an email statement by the Arts Commission's Chief Financial Officer to the Program Director Howard Lazar, explaining the 5% administrative charge, which was levied on Street Artist Program. The document states, we already went through this, but I'll say it again, sorry. The Arts Commission Management Team meeting, which is comprised of the Director of Cultural Affairs, the Director of Programs, the Director of Grants, and the Chief Financial Officer, decided to charge the Director of Cultural Affairs and the Director of Programs a supervision charge to be fixed at 5% of their total hours spent across all programs, which is relatively liberal compared to their actual effort and time spent on the Street Artist Program for the year. Accordingly, the attached document was processed in FAMIS. The processed FAMIS document was also included in the document sent to the clerks. In further compliance with the order, the Arts Commission representative attended the Compliance Committee meeting on March 8th and read the above passage to the committee. We made it clear to the Compliance Committee that we have no additional records explaining the 5% figures. The Arts Commission, therefore, in furnishing all relevant requested information and appearing before the Compliance and Amendments Committee on March 8th, complied with the order of determination.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matters with the task force. Are there any questions for the complainant or the respondent? Okay, at this time, the respondent and then the complainant will each have 3 minutes to make any concluding or rebutting remarks. Mr. Matos? Okay. Mr. Clark?
Thank you. As I stated at the Compliance Committee, the email that he just read to you was different than the email that I received from the Arts Commission. And I think I included the email that I received in your information packet, so you should have it. I don't have it with me tonight. But basically, the email I received was not the exact same email that he sent me. The email I received just stated that the members, the committee members were Mr. Kinsell, Ms. Menton, and Mr. Hun were the only ones who attended that management team meeting. And basically, it just said the statement which I stated earlier, that Mr. Tun thought that it was a reasonably liberal figure to charge us 5% of the Mr. Kinsell's and Ms. Montan's time that they use to supervise and manage the street artist program. So I just want to make that clear that although it's almost the same thing, and maybe in substance it's pretty much the same, the exact language was different. And I haven't seen a copy of his email yet, and perhaps I overlooked that when I should have looked in the file, but I didn't do that, and I'll try and get a copy of that later on. So I just want to make that point that the only people that were at this meeting were 3 people: the accountant, Ms. Manton, and Mr. Kinsell. This meeting took place 1 month after the end of the fiscal year. The supervision charge that they charge was never on the budget, was never considered at any previous hearing. The public was never made aware that they were going to be charged that. They were never told that they were going to discuss this charge. There was never a hearing at the Art Commission Street Arts Program Committee regarding it. There was never a hearing at the Arts Commission level to discuss it. And there was never a hearing at the Board of Supervisors Finance Committee, and there was never a hearing at the Board of Supervisors itself where we were being told that we were going to be charged this fee. This was decided by 3 individuals who, after the end of the fiscal year, did this on their own, and that's why we're asking that, and we think that we should be able to get some explanation as to how they determined that they spent 5% of their time on the program, because from our standpoint, it could be 1%, it could be 0.5%. There should be some way that they should be able to validate this 5% charge. Thank you.
Thank you. Matters back with the task force. Is there a motion? Member Washburn?
This whole matter, I find it very frustrating for a number of reasons and very difficult to think about. On the one hand, I can imagine the financial staff person, working on a budget and trying to figure out how, where funds are going to come to pay various employees, and pulling 5% just almost out of the air with consultation, and there's no more record than that. The 2 employees whose time was going to be covered by the Street Artists Fair's fees, saying, "Well, yeah, I spend about this amount of time." I can imagine it being that casual, in which case there's not a whole lot that they could say other than what they did. At the same time, I think that it's if that's the way it happened, it's regrettable. I think that that city departments should be able to justify their budgets, their different, for staff, which is their biggest expense. So those are just my thoughts. I'm just sharing this with the members. I don't know what else to say at this point. Would like to hear from other members.
Member Knebber?
I would like to hear from members of the Compliance and Amendments Committee as to why they felt this should be referred on to the Ethics Commission.
Member Washburn?
Gosh, I'm trying to remember. Well, one of our frustrations is that the Arts Commission, with all due respect to Mr. Matos, never send anybody who can actually give us information. Mr. Lazar doesn't come. He sends somebody with a written statement. So we feel like we've been hampered in our, fact-finding by that. So that's part of what's going on. But again, I'm as I shared, Yeah, I can imagine the city saying, the department saying, we've given you all the information we have.
Member Wolf?
Yeah, I would just further add that Mr. Larzar has been before us on this matter, and has outright said he doesn't have it or won't produce it or what have you, and just continues not to show up himself and answer the questions. So it just feels like a level of avoidance and noncompliance to do it.
Member Knebber?
Now that I certainly agree with. I have a level of frustration with the respondent after many meetings here. However, this actual agenda item is saying to refer to the Ethics Commission for noncompliance. And it brings me back to the same problem. They say there's no document. The complainant says there has to be something, just because there has to be. And believe me, I'm very sympathetic to that. But it's plausible to me that there is no document, that 5% is 5%, that they just said that, hey, it sounds like 5% is a good number, and that's what they said. And we have talked about holding them accountable for verbal information, and their verbal information is that it's 5% because we think that's a reasonable number. So I have a bit of a problem with referring this one specifically to the Ethics Commission.
Member Johnson, Member Cawthon.
Can you verify that that's what they're saying? Mr. Matos, is that...
Mr. Matos, please approach the microphone.
Can you respond to that? Is the Arts Commission representing that they've determined 5% and there are no documents and it's just 5% of the time?
Yes, it's just 5% of the time. I don't know if I can actually say one other thing about this. Mr. Clark said that he didn't receive the email, but the last meeting that we actually attended, he actually read off the email, the exact same email that he's actually referring that he did not receive. And it was actually included in that email that I read off tonight, just that brief.
Can you tell us how the 5% was reached?
I brought the documentation the last time around.
Well, the email. All I'm asking is, do you know how the 5% was reached? Was it off the top of their head? Did they keep their time?
That's what they came up with. Because the split, pretty much there's multiple programs that's actually provided by the San Francisco Arts Commission. So what they did was they did a analysis of the whole programs that's actually taking time away from their general work. And what they did was they're taking that budget, and that's where the 5% is usually coming from. That's why they say.
Are there documents associated
there's
with
no documentation
with the analysis?
That's their final breakdown of all the programs that's actually underneath their umbrella.
Do you know if there are documents associated with what you're calling the breakdown?
The breakdown was the documentation that I actually provided to you guys on, I do believe that it was...
The FAMUS?
Yes.
Or famous, however you...
Yes, the breakdown was actually all implied in there, the hours and everything.
You're representing that is the only documentation?
That is the only documentation that I have actually come across that they have actually provided to me, and also what I've actually discussed with Howard Lazar.
Okay.
Okay.
I think when we did the ethics commission, when we referred it from the ethics commission, it was difficult to determine if what you said was accurate. If we were actually getting the information if we were actually being presented with somebody who could respond to those kinds of questions. Although he seems to be today representing that that's the case.
Member Cawthon, Member Wolf.
I have a little bit of trouble with this one also. The problem is that they did say it's an estimate. Mr. Matos said that they did some analyses, and we've got the analyses, and there are no other documents. I don't see how we can send something to the Ethics Commission based on alleging willful misconduct when we're basing it on, as it says in the order, on a supposition that a document exists. That just won't hold water. Ethics is tough enough when you've got real solid hard facts like I did in my case. But if you're basing something on a supposition. I don't think that's going to go very far with them.
Member Wolf?
So the concern I have with this is that, with all due respect to Mr. Matos, he has, in previous hearings, has said that he doesn't know anything beyond the questions that we're asking. I mean, he didn't have enough information. He wasn't knowledgeable enough. And today, to me, it just feels like, well, that information is now public. We've already discussed that, easily repeatable. My concern is that we have had many other departments on similar occasions have produced documents of exquisite detail about specific time spent and how much was charged. Even within this case, I believe that the city attorney's office, I think it was this case, city attorney's office provided documentation of a breakdown of how many hours and how much the charges were for almost each and every instance. I mean, that's a pretty serious amount of micro bookkeeping that I can't understand for a staff of 5 or 6. You can't break down what each person makes and what they do as part of those duties. And I'm sure we can find other examples. The question becomes is, they say, well, we don't do it in this office, but there are other offices that do it. What's the requirement of the city? If the requirement of the city is you must do it this way, and then they don't do it, then they have to then go produce it. It then doesn't become extraneous to Sunshine. It becomes something that they've omitted in doing based upon just existing under the city umbrella. So I'm a little concerned that this case is gone on for as long as it has, and how many times we've asked this question of where this document is. We know that they know how much people get paid because they got to produce a budget every year, but that somebody has to be doing some bookkeeping, and there has to be something. Now, if they want to charge the clerks for producing a brand new document, as long as they get the clerks are able to get what they can, so be it. But they're not even willing to do that. They're not even saying that they can do that, which I cannot believe. So to me, it feels like an avoidance. It feels like willful failure. We don't want to do this. Leave us alone. Go away. That's what it sounds like to me.
At the very least, we have 67.21E. Mr. Matos has appeared before us, and we appreciate his having done that. And he's represented the Street Artist Program and the Arts Commission to the best of his ability. Unfortunately, his knowledge in this matter is limited to what he's given to present to us. And so, at the very least, we do have violation of 67.21E, and it's a pattern that the Arts Commission, over the past several months, has evidenced. Mr. Lazar, we realize, has been out ill for a while, but I don't think that excuses. I don't think that excuses this. When Mr. Lazar is not there, there must be somebody else there to fulfill at least part of his functions. And again, even if we have a problem convincing the Ethics Commission that there is violation on these other matters, not withholding, not justifying the withholding, not providing oral information, even if they plunk that 5% figure out of thin air, that may not be something that we can address here. Maybe it is. But even if it isn't, that should give pause to the budget crunchers upstairs including the mayor, the Board of Supervisors, the Budget and Finance Committee, that they should take a serious look at what the Arts Commission is getting. How much we're getting for our money that's spent on the Arts Commission and on the Street Artist Program. Is there a motion?
I move that we find the Arts Commission in violation of 67.21E and write a letter to them or to the Budget and Finance Committee of the Board of Supervisors urging that they look at the Arts Commission's evaluation of how it spends its money.
Okay, the violation of 67.21E was earlier found. The question before us is, do we refer this to anybody? Do we refer this to ethics? Do we refer this to the Board of Supervisors? To whom?
Could I just continue?
Member Cawthon?
I just think it would be really wrong to send this to ethics on the basis of a supposition.
Is there a second to Member Cawthon's motion?
Motion was, I'm sorry.
Please repeat the motion.
Was find them in violation of 6721E for not setting somebody knowledgeable.
Okay, that's already been found.
Oh, sorry. I wasn't here.
Do you wish to forward? Do you wish to refer that violation to any of the enforcing entities? Ethics, Board of Supervisors, District Attorney, California Attorney General.
Not based on the document.
In the microphone.
Not based on the document per se, but based on failure continued failure to send a knowledgeable representative.
Do you wish to make that a motion?
I thought it was already a motion that passed.
Yeah, no. This is to see if we want to.
Do we want to refer this to an enforcement entity?
Yeah, you want to refer that because they're not showing up to refer to ethics.
Well, we've always done it, but it never gets anywhere. So.
Member Washburn.
Well, since that never gets us anywhere, why don't we send? I move to send this matter to the Board of Supervisors.
Is there a second?
I'll second it.
Moved and seconded. Discussion. Member Johnson, Member Wolf.
I don't think that it's very frustrating for Ethics Commission to not enforce our orders, but I think out of consistency, we should not consider their lack when we forward something. We need to be consistent and demand that they continue to demand that they address what they're supposed to address. So I think that I agree with Chair Nee that Mr. Matos has represented to the best of his ability, but really we cannot find it. We're always guessing like we are now over and over again. And if Mr. Lazar would send somebody who could make these statements or just make them himself, it wouldn't go on that long to say, yes, we pulled it out of thin air. I mean, then there's not much we can do. But I don't think that the board will do anything either, and I think that we need to be consistent with our rulings.
Member Knebber?
I agree with the consistency notion. Just because the ethics won't enforce it, I do think that the precedent of repeatedly sending stuff is a message in itself. So I would move that we do forward it to the Ethics Commission.
Okay, this is a substitute motion?
Substitute motion.
Is there a second?
I second.
Moved and seconded. That is a substitute motion. That is the motion that is now before us. Is there discussion? Is there public comment? Member Wolf.
I would just say that you have to name a person. You can't.
Yes, I apologize for my motion. I do name Mr. Lazar.
Okay. Second accepts?
Yes.
Second accepts. Okay. Member Wolf?
That was my
okay.
point.
Is there public comment on this motion?
Thomas Piccirillo. You know, I would like to see the task force refer orders of determination to someone else other than the Ethics Commission. So, city attorney, district attorney, I didn't know the Board of Supervisors had jurisdiction on orders of determination, but if they do, that would be my suggestion. We all know what happens with orders of determination when they go to the Ethics Commission. So you may want to start using another enforcement agency to enforce your orders of determination. Secondly, let me say that procedurally, if you look at items 22 and 23 on your agenda, they haven't really been adopted by the task force. They're recommendations by committees. Yet you discuss the matters of the complaint committee and the compliance and amendments committee as if they've been adopted. So my suggestion is you should probably put the reports before any items on your agenda regarding any sunshine violations. Thank you.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Further discussion. Member Johnson, Member Wolf.
Could somebody address what, if we did send it to a different enforcement agency, what would be their jurisdiction over it? Or, for example, in this, if you send it to the board or the city attorney, what could the potential outcomes?
Member Wolf, Member Washburn.
So my statement will probably answer your question. So first of all, we would be able to do this under 6730C. It basically says any municipal office with enforcement power. So what's the enforcement power of the board and supervisors? Well, they can withhold money, budget. What's the enforcement power of the district attorney? They could prosecute. It's like kind of a civil case, prosecute against to compel them to get a court order to do something. Same thing with the state attorney general. They could compel them to do something. We could also refer it to the Arts Commission itself that oversees this particular department, and if they have the will to be able to do something about it, they could compel them, by virtue of their oversight, to compel them, or say we're going to withhold your budget, or we're not going to fight for you on this part of the budget, or something. They could. There are ways, at different places, that you can refer this to in order to bring enforcement. Enforcement doesn't necessarily mean legal enforcement.
Member Washburn?
I was thinking the Board of Supervisors would be a good place because of budgetary considerations, and that's their purview. And so this matter is, and a lot of what we're hearing from the street artist program has to do with, the artists are the ones who are paying for the program's administration. So there are issues with how the budget is allocated, and then where the money comes from to make the payments. So these seem like issues that the Board of Supervisors, it seems like it falls in their, in their domain more so than ethics, in my opinion.
Member Johnson.
I would remind the task force that the Board of Supervisors approved a budget that required the street artists to pay specifically for the Sunshine Ordinance. We had before us the budget where the Board of Supervisors approved a certain amount of money to be charged to the artists, even though the Arts Commission represented it was specifically to cover the costs of the Sunshine Ordinance. So I hardly think they're going to reduce their budget, but I do like the idea of addressing the Arts Commission, because when I did a training before the local homeless coordinating board, some of their members were unaware of the orders of determination and seemed to be concerned when they found out. So perhaps we could send it to more than one enforcement agency.
Do you wish to amend the motion?
To add is it the Arts Commission that?
Well, the Arts Commission is actually the the named violator here.
And they're only overseen by the board?
By
So-
the Board of Supervisors and perhaps the mayor's office.
So we're back to the
Yeah.
square one.
But, okay. Let's call it.
The motion is to refer this matter to the Ethics Commission. Roll call, please.
On the motion, Member Cotton? Aye. Cotton, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
No.
Washburn, no. Member Knebber?
Aye.
Knebber, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 8 ayes and 1 no. The motion passes.
Thank you. That concludes this matter for the moment. We'd like to thank both sides for attending. Mr. Clerk, could you read item 11, please?
Item 11 is hearing on complaint filed by Anonymous against the Department of Recreation and Park for allegedly not releasing public information related to a Rec and Park Commission hearing.
Okay. This matter, the jurisdiction in this case has already been accepted at our previous meeting. Is the complainant present? Is the respondent present? Is there anybody here to present facts and evidence? Well, if neither the complainant nor the respondent is present, it seems to me, didn't we table this matter last time?
Yes, we did.
Okay. In that case, this matter is this matter is put to bed. Will not be heard unless it is refiled by the complainant. Items number 12 and 13 have been continued at the request of the complainant, who was called away on urgent family business. Could you read item 14, sir? Mr.
Yes,
Clerk?
Mr. Chair. Item number 14 is determination of jurisdiction on complaint filed by Mary Miles against the Planning Commission for allegedly refusing to respond to an immediate disclosure request.
I move we find jurisdiction.
Moved and seconded to find jurisdiction. Is there any public comment on the jurisdiction question? Seeing none, roll call, please.
On jurisdiction, Member Cotton? Cotton, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber?
Aye.
Knebber, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Yeah, Mr. Chair, we have 9 ayes.
Thank you. That takes us to the substance of the complaint. Ms. Miles, thank you for coming, ma'am. You have 5 minutes.
Thank you, sir. I'm Mary Miles. I am the complainant in this complaint.
Could you speak into the microphone, please?
Can I be heard?
Yes, that's
All
fine.
right.
Thank you.
I'm Mary Miles, the complainant. This complaint is fairly cut and dried. As you know, the Administrative Code, Section 6716 states, quote, and I quote, "The draft minutes of each meeting shall be available for inspection and copying upon request no later than 10 working days after the meeting," unquote. I requested the February 10th Planning Commission hearing minutes on February 23rd. I assumed, of course, that they would be available February 25th. I received a response from the Commission Secretary, Linda Avery, saying that they were not available. It didn't say when they would be available or if they would be available. They just said they weren't available. I then sent a formal IDR to the Director of Planning, Mr. John Rahame, and to Ms. Avery and to Mr. Smith. I received no response at all to that. Later, there were more email exchanges, and we ultimately did receive the minutes, but we received them not until March 9th, 2011. Now, that's clearly more than 10 working days after the meeting, so I urge you to find a violation of Section 6716 for failure to make the draft minutes available for inspection and copying on request no later than 10 working days after the meeting. I do have copies, if the task force wants them, of the complete email chain that ensued there. I'm not sure you have the complete record, which I can present after the meeting, or if anybody needs that to make a determination here. In that same request of February 23rd, I asked for a court reporter's transcript of the February 10th, 2011 meeting on the Park Merced items, or at least the contact information for the court reporter who was present at the commission hearing. I never received the contact information, and I only received the transcript on March 9. There's no response to my IDR again. Those bits of correspondence, I believe, are in your packet. I think this is, again, cut and dried, a violation of Section 67.25A for failure to timely reply to an IDR. There's a fundamental problem at the planning department, which is recurring, and there seems to be a lack of a main point person for public information and sunshine requests at planning. With the exception of Brian Smith, who came on board quite recently and sometimes handles them, there's just frequent obstinate finger pointing between planners, Linda Avery, Lulu Wong, and others who seem either ignorant, incompetent, or hostile to their responsibility to provide timely information to the public. There seems to be some kind of underlying hostility based on some sort of reaction to and imply that someone's belief about why the request is being made, which is irrelevant. The public servants have a duty, and I would call it one of their highest duties, to inform the public, regardless of the public's reason for the request. Now, whether a lawyer, a neighborhood activist, or just an interested person, it shouldn't be so hard to get information. I have spent hundreds of hours reviewing documents at planning while being subjected to incredibly nasty and obstructive tactics over the past several years. Recently, I've had to go around several times with planning staff over the 1 cent versus 10 cent charge that's pretty well set out in Section 67.28 of the ordinance. To conclude, perhaps I've digressed from the main gist of this complaint, but I urge you to find violations of 6716 and 6725A and to require retraining of planning staff on their sunshine requirements. Thank you.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Seeing none, is the respondent present?
Mr. Chair, you have an email from Mr. Brian.
We have an email from Brian Smith dated March 22nd, which is today. It says, this record request was completed on March 10 upon receiving the completed minutes and hearing transcript. Attached is the email to Ms. Miles with requested documents. We understand Linda Avery was late with finalizing the meeting minutes for the February 10th commission meeting and will accept the SOTF findings against us for this indiscretion. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matter is with the task force. Do we have any questions for the complainant? Member Knebber, Member Wolf.
Ms. Miles.
Yes.
you said it and they said it. I just wanted to make sure. Have you seen these? Have you seen these draft minutes?
I did get them. Yes, I will
Okay.
acknowledge that, and I will.
And you acknowledge it was on the 10th of March, which is
10th
well
of March, which was
well beyond.
well
Okay.
past the date when they should have been provided.
Okay. Thank you very much.
According to the rules.
Member Wolf?
That was
Member
me.
Cawthon?
That was
Okay.
me.
Member Cawthon?
I just wondered, did you get the transcript?
I did.
And how long did it take them to give that to you?
Again, that came a little later, but it came, I believe, on the 10th.
Okay.
Member Johnson?
I don't have any questions for the complainant, but I don't know about the transcript, but the draft minutes should have been done within 10 working days, even if it was just a skeletal draft minutes. And I'd like to point out that this is about Park Merced, a very controversial issue in the city. That makes it a little bit even more unfortunate that the only thing that they would send to us is the idea that they'll accept whatever it is that we are willing to provide without sending a representative. I don't like that.
Member Kneber?
Ms. Miles, just to be very clear, on your IDR immediate disclosure request, did you get anything from them back within that 10 days stating?
We first got a very small email from Ms. Avery
I've seen it,
saying,
yes.
I don't have the minutes. They're not available. I don't, didn't say anything more than that. I then sent another, a more formal IDR
Okay,
to the
that's what I wanted
planning,
to ask.
and we got nothing in response to that.
Nothing in response after that
Nothing
IDR.
at all.
Okay, thank you.
Until the final production.
Member Johnson?
You didn't get a response by the close of the next business day to your IDR?
No, I did not.
Yeah, there's two separate. The original, if I'm understanding, the first was not an IDR; it was just a request, and then you got back a formal. Later you filed a formal IDR, and you never got a response to that. Correct?
That is correct. But hold on. I must correct myself now. The February 23rd request to Ms. Avery was headed an immediate
Okay.
disclosure request. She did respond within 24 hours, stating the draft minutes for 2/10/11 have not been done yet, and I don't have any indication of when the transcript for the Park Merced item will be completed and submitted to the department. That
Okay.
was her sum total answer to me. I then submitted that same day an IDR saying I didn't regard that as a satisfactory
Okay. Thank you.
disclosure, and please.
Okay. Thank you.
Got no response from that one.
Okay, at this time, the complainant has 3 minutes to make any concluding remarks.
Again, I would say that even that this, by the way, is the rule rather than the exception. If you go back to the beginning of the Planning Commission, you're going to find it's very difficult to get those minutes within a 2-week time period. And it matters if you're appealing a matter such as Park Merced to the Board of Supervisors. If you're appealing a Planning Commission disposition, you kind of need to know what happened at the commission meeting. So it can take on a certain importance in that respect. And it's not just those things. It's, as I said, there seems to be a problem with the right hand not knowing what the left hand is doing with a lot of information requests there. Even if Mr. Smith is very, very good, you often encounter this hostile attitude at the front desk that seems to you don't know where it's coming from. Public disclosure is public disclosure. It's not a political agenda.
Thank you. The matter is with the task force. Member Kneber?
I definitely think. I definitely think. I would move that we find violation of 6716 because they did not provide the minutes within 10 working days of the meeting. And the second point, it's a little bit less clear to me, but I am convinced that there was a violation of 6725A as well. because even though they said they're not done, they did not give one of the given reasons in B for why they couldn't immediately disclose the item. So I would move, again, just to sum, I would move for a violation of 6716 and 6725A.
Is there a second?
I'll second it. And I want to ask the maker if you want to have any direction for it, what should happen.
We've gone back and forth with the planning department, but this is a bit different. So I think that giving the benefit of the doubt, I would say to training first.
To EOT?
Yes.
Okay.
Member Johnson?
I would like to suggest adding 6721E for failing to send somebody here and just assuming that they would take it because Park Merced is pretty controversial. And in addition, because of that, I would also suggest adding CPRA 6253 C and D.
Second accept?
Yep.
Maker accept?
I do not, because the only reason is because they sent the letter and they said they take full responsibility. If they had sat down saying that we don't need to do this or hadn't said anything, I would feel more inclined to accept that.
They're taking full responsibility because Park Merced is really controversial and they got away with not doing the documents.
What about 6721E? Okay, the maker of the motion does not accept those amendments, so as it stands now, we have 67.16 and 67.25A. Member Wolf?
The only thing I could say in response to Member Johnson's statement is that what was reported was only based upon the final minutes, not on what the complainant was asking for. The letter did not describe anything with regards to draft minutes. It only described lateness and incompleteness of the full minutes, the final minutes, not the draft. She was asking for the complaint. The complaint is the non-compliance of the ordinance to produce draft minutes, period, within 10 days. So that is what's before us.
Member Johnson?
It's what?
I'm sorry,
in the
Mr.
letter.
Freed?
Through the chair, I just was going to point out that in the Ms. Avery's response on the 23rd, I believe, she did address the draft minutes. She said she had not completed them and she was not sure when they would be completed.
Member Johnson?
To go to that point, the draft minutes are required whether they're complete or not. That's a draft. But I would like to point out that 6721E requires attendance at these hearings, and there is no provision allowing for a letter to substitute for requiring attendance at hearings. And because we're having a problem getting people to come here, we need to require it or not. Otherwise, it's wishy-washy. So I really urge you to add 6721E.
I have had a change of heart from the testimony, and I would accept 6721E.
Second accept 67.21E?
Yes.
Okay, so that adds 67.21E. Further comment? Is there public comment on this item? Seeing none, public comment is closed. Roll call, please.
On the motion, Member Cotton?
Aye.
Cotton, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber?
Aye.
Knebber, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 9 ayes. We have motion passes.
Thank you. This matter is referred to the Education, Outreach, and Training Committee.
Thank you.
Thank you, Ms. Miles. Mr. Clerk, could you read the next item, please?
The next item is determination of jurisdiction on complaint filed by Mary Miles against the SF Municipal Transportation Agency for allegedly refusing to respond to a public records request.
I move we find jurisdiction.
Second.
Moved and seconded to find jurisdiction. Is there public comment on this item? Seeing none, roll call, please.
On jurisdiction, Member Cawthon.
Aye.
Cawthon, aye. Member Manny.
Aye.
Manny, aye. Member Washburn.
Aye.
Washburn, aye. Member Knebber.
Aye.
Knebber, aye. Member Costa.
Aye.
Costa, aye. Member Wolf.
Aye.
Wolf, aye. Member Chan. Chan, aye. Member Johnson.
Aye.
Johnson, aye. Member Nee.
Aye.
Nee, aye. Mr. Chair, we have 9 ayes. Motion
Thank-
passes.
Thank you. That takes us to the substance. Again, Ms. Miles, thank you for coming, and you have 5 minutes.
Thank you, sir. I hope I can complete this. This is a bit of a different issue here.
Can you pull the microphone closer, please? Thank you.
Again, Mary Miles, complainant. We have a slightly different issue here between MTA staff. You have a large volume of email back and forth between me and the MTA staff on this, but you don't have the full volume of it. This is one single request. You can see what I requested in the facts. I would say the first paragraph of the uncontested facts is correct, and as far as it recites what I did request here, and I regard this as a very simple request. It had to do with the MTA board agenda for February 1st of this year. I received nothing except another copy of the agenda. I would take issue with the skeletal nature of the rest of the recitation of facts here, as it is a rather truncated version of what actually took place. And I'm not sure that you want me to recite every bit of correspondence that went back and forth, but I would say that that some of this doesn't get to what actually happened here, and sort of whitewashes it a little bit because of the lack of completeness. We went back and forth on the emails. I did receive a response on January 31st, which included just another copy of the agenda. We went back and forth again, and I told them exactly, tried to explain in plain English again what I needed. Since the meeting on the MTA board was occurring the following Tuesday, this being Friday, I needed the items quite quickly in order to submit meaningful comment on the substance of the issue. In fact, I had to request a continuance, which was totally ignored by the MTA board, and I got none of the information in time for that hearing. The MTA alleges that insofar as this is deemed allegations, I would not dispute it. If it's not deemed allegations but is deemed facts by this task force, I would dispute some of this. The back and forth on this thing was stupendous and enormous, and I didn't get, the bottom line was I never got the material until it was finally produced 6 weeks later on March, I believe it was March 9th. So, there was a 6-week period. First, I got a pro forma. My first part of this complaint is the pro forma nature of all MTA's responses. We always get, in response to an IDR, this pro forma 14-day extension. To me, this did not warrant a 14-day extension. There's no justification for that, especially in view of the meeting that ensued the following 5 days later. MTA alleges the CD was not picked up. I did pick up. I made three trips to MTA to pick up things. First, they presented a CD that was blank. That's missing from the facts. They sort of put out another pro forma apologia for this. Then I got a CD face down without a wrapper on my doorstep on February, I guess it was 18th, when that was dropped on my doorstep. It was damaged. It froze my computer. I tested it on another machine, and it froze the other person's machine as well. This game went on for weeks and weeks and weeks, this back and forth, this sort of game playing by MTA in response to this simple request. MTA does have a point person, unlike planning. Ms. Carolyn Celaya, I'm sorry, I've taken too much time already, although I wish I had a little bit more.
Thank you.
You're welcome. Thank
Is
you.
there anybody here to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Mr. Rustum?
Mr. Chair, I got a phone call from Roberta Boomer at about 3:45 this afternoon saying that Miss Caroline Celia had planned to attend but had gone home sick.
Thank you. Matters with the is there anybody to present facts and evidence in support of the respondent? Seeing none, the matters with the task force. Member Wolf?
I just case after case after case, they don't show up. I'm wondering if we have the ability to verify whether these people actually did leave. Come on. It gets a little maddening after a while. Ms. Miles, how many did you receive? I may have missed it, but did you receive 2 discs or only 1?
I received I received 2 discs. The first was blank. I went to MTA to pick it up,
Okay.
Took it home, played it. There was nothing there.
Yeah. Okay. All right.
The second was damaged so that it, yes.
Okay.
Anyway, I'm sorry.
Thank you. That's all the questions I have.
Mr. Threed?
Through the chair, I just want to clarify that ordinarily, under issues to be determined, there's a factual recital, and these are the allegations of the parties. I don't have any facts that I've independently investigated or verified for in any way. And usually what I have here is uncontested/contested facts, and for some reason that I don't, I guess it was just I didn't notice it before. It says uncontested facts. These are not uncontested facts. As you can see, the facts are contested by the parties. So my apologies.
Okay, thank you.
This is page, Member Wolf, page 2 of the memorandum.
Is that this? Which memorandum are we? Do I not have that?
One that was emailed.
Extra packet.
Is that the one that's noted 12 and 13?
Yeah, it's in the middle.
So there's a whole bunch.
Oh, but this is.
It's in the middle of 12 and 13.
Oh, okay. Oh, I see. I'm sorry.
Member Johnson?
Table of contents, sir.
Ms. Miles, could you just briefly help me go through the timeline again? You made the request for the 2 sets of documents on
January 28th. That first paragraph is correct.
on January 28th, and you wanted them in time for a meeting that was to occur when?
February 1st was the MTA board meeting that considered the item
And so
which I requested.
These items were from that agenda. They were not
Exactly.
available online by clicking on the agenda. Is that
No, the second item requested is not something you can get online. The agenda you can, and apparently
But the
skeletal packet materials.
was item number 2 something that the MTA board was receiving as well, or was that something extra that you wanted for the meeting? Not extra, but something of your own that you wanted for the meeting?
I requested it with reference to the meeting as the MTA files on the traffic modifications proposed in item 10.2 on the MTA board meeting agenda for February 1st, 2011. And I thought that was specific enough, but I'm always, and MTA is aware that I'm always glad to narrow or clarify my requests if needed.
They understood, you feel that they understood what you wanted?
They never asked me to clarify. I assumed that it was a simple enough request. It's something that the board needed to have in front of them in order to determine whether to vote yes or no on that agenda item.
Do you know if it was an extremely large volume of documents?
It was quite large, as it turned out, when they finally did produce it. It was about a ream of paper, I would say.
Do you know that were any of those documents referenced at the meeting?
That I don't know. I'm sorry.
Okay. Is this, can you give me some indication of what the traffic modifications were about? Just
the board has proposed fairly radical changes to Cesar Chavez Street, in which they're going to eliminate traffic lanes and all the parking in order to make bicycle lanes and a livable streets something there.
Okay. Thank you very much.
Okay, at this time, the complainant has 3 minutes to make any concluding remarks.
Thank you very much. I would ask the board to find violations of Section 16.21A and Section 6725 for failure to timely respond to an immediate disclosure request. Regardless of what the volume of material produced, this was not an obscure request that should have required compilation or any other reason for delay. It was something that should have been readily available and in front of in the packet of the MTA board. By delaying it, there are all kinds of problems with causing the public to have to go through this for a simple request like that. First, the time consumed, the frustration and exasperation of having to repeat and go over and where is it and why am I getting a blank disc? What happened here? Can you just make me the disc? Can you get me the paper if you can't make the disc? Why does it take this much paper to do that? Secondly, of course, the public is denied the information that's necessary for meaningful comment, for meaningful participation in these public proceedings if they can't get this timely production. And as I said, I asked the board for a continuance due to the lack of information. Of course, that got round filed, and they just went merrily on and okayed the project without anybody knowing what they were doing. Like I said, whether anyone agrees with the public's reason for asking for something, that's irrelevant to the higher duty of the public servants to provide this information, and it's one of the highest duties of their position. What can be more important than keeping the public informed? Especially if it matters for a meeting, especially if it matters in a decision-making process. So I would ask you to find in favor of my complaint, to sustain my complaint here.
Thank you. Matters back with the task force. Is there a motion?
I think we should find them in violation of 67.21 and 67.25 for untimely production, and also 67.21E for failure to send a knowledgeable representative.
I will second that only if you add 67.16.
I'm sorry?
67.16, requirements for minutes. at public meetings.
Okay, 67.21,
25,
25.
and 21E, and 16.
Oh, that's the wrong. Why the 16? You're getting
I would, Member Wolf, what would you, through the chair, what would your reasoning be for the minutes? I would say I could see agenda items, but
Is there a second?
He seconded.
Hold on.
There has been a second?
Yeah,
Okay.
I second it.
Okay. Member
Oh,
Wolf?
I'm sorry. I was looking at the wrong one. No, not 16.
What,
21 and 25. So everything that Member Cawthon said except for 16. 16, I made a mistake.
Okay, so you withdraw a second on 16?
He withdraws the second, and I withdraw the motion, that portion of the motion.
Okay. So we are left with the motion and second are to find violation of 67.21, 67.25, and 67.21E. Is there public comment?
Thomas Piccirillo. Does anybody see a pattern here? The respondent doesn't provide the documents and then doesn't show up. This case, though, gives you an opportunity that you haven't had in front of you. The IDR was made to Nathaniel Ford. My suggestion is if you do make an order of determination in favor of the complainant, you refer this matter to the Attorney General, and perhaps then you'll have more compliance by the MTA regarding disclosing records in a timely manner and showing up for your hearings. Thank you.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Member Wolf?
Yeah, I would. I think we failed to add that to the motion as to the disposition. What should we do with this? And I would agree with the public commenter, Mr. Piccirillo, to send it to the Attorney General under our authority to do so under Section 6721E.
Mr. Threet?
Through the chair, I would simply suggest if the task force is considering a referral to the Attorney General that they cite to violations of the Public Records Act, which is what he has jurisdiction over.
What section? 67. What is it? What's the number?
6253.
32. Okay, I don't have it in front of me.
Can we easily amend it to refer to Section 6250 et sequitur of the California Government Code?
6253
53.
governs the release and of records and the timing of responses.
Okay.
And who are we finding the violation against?
Nathaniel Ford.
MTA.
But Nathaniel Ford was the named respondent.
Okay. Just for the record, though I don't always agree with everything that goes on, Mr. Piccirillo was accurate that this is a pattern, and I think it's kind of a frightening pattern because Ms. Miles is well known for her opposition to bicycle lanes throughout the city. I recognized her myself. So if you're involved in that transportation in any way, it's well known that she is seeking the information and that she will actively use it. So I think it's very unfortunate that they didn't show up here, and I do see a pattern of game playing with people that are known to really use the information that they're seeking.
Do we want to refer this to any other entity? And I ask for a couple of reasons. First of all, as Mr. Threet points out, the California Attorney General will get involved only on a matter of the state law. Second, and so that, the Attorney General is not going to get involved with the other three sections here, the Sunshine Ordinance sections. The other question here is that in the past, when we have referred matters to the California Attorney General, we have gotten a response back saying the California Attorney General does not involve itself in local matters. That was under Jerry Brown. Now maybe Kamala Harris has a different attitude on it, but do we want to refer it perhaps to the district attorney as well, and perhaps particularly on a 67.21E matter to ethics?
Okay. I'm game.
Member Knebber.
I mean, in this case, I think that I think it's appropriate to do all three. I think that we could refer with and say, hey, this is something that we find very egregious, and we want to make sure that we have it out there.
Okay, so this is a friendly amendment then to refer to ethics and the district attorney as well as to the California Attorney General. Is that correct?
Member Cotham.
Okay.
I have a question.
Member Johnson.
When we refer something like that, does the mayor or the board of supervisors get notified? I'd like to see them. What's that?
We could copy them. It wouldn't directly go to them, but we could copy them as.
I would like to see them copied as well.
That's okay with me, Member Cotham. We should remember this very key, this is duplicatable and replicatable.
Okay.
This particular kind of case.
Is there public comment on this item? Seeing none, public comment is closed. Further discussion. Roll call, please.
On the motion, Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber?
Aye.
Knebber, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 9 ayes. The motion passes.
Thank you. Could you read item 18, please?
Item 18 is determination of jurisdiction on complaint filed by William Clark against the Arts Commission for allegedly refusing to respond to a public record.
Is there a motion to accept jurisdiction?
I move we find jurisdiction.
Second.
Moved and seconded. Discussion. Is there any public comment on the jurisdiction question? Seeing none, roll call, please.
On jurisdiction, Member Cawthon?
Aye.
Cawthon, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber?
Aye.
Knebber, aye. Member Costa?
Aye.
Costa, aye. Member Wolf?
Excused.
Wolf, excused. Member Chan?
Aye.
Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 8 ayes.
Thank you. That brings us to the substance. Is the complainant present? Thank you for coming again.
Yes.
And again, you have 5 minutes.
Oh, thank you. Again, I'm William Clark, I think. Okay, this issue on February 3rd, I sent Mr. Louis Kinsell, the Director of Cultural Affairs of the Arts Commission, a request for public information, and also a request for the draft minutes of the Executive Committee of the Art Commission for a meeting which had taken place a year before, and the minutes had not been posted as of that date. I did not receive any response from Mr. Kinsell until March 2nd, a day after I filed this complaint with the task force. The reason some of the questions that I asked Mr. Kinsell, I did receive an answer from that I'm satisfied with, but one of the questions I asked him, I did not receive a satisfactory answer, and I did receive the copy of the minutes. However, I asked Mr. Kinsell, this is in regards to the management team meeting again that occurred, I forget the date now, but I believe it was in July 28th of 2010. And this was before I knew who was on the management team, and I was trying to find out. And I asked Mr. Kinsell what was the actual vote tally taken by the management team regarding the decision to charge the Street Arts program $18,875.18 for management supervision charges for the 2009-10 fiscal year. The response I got from Mr. Lazar was, there is no public record of such a vote tally. I didn't ask for a public record in that regards. I simply asked them to tell me what was the vote of the management team. At that time, I didn't know who was on the management team, so I didn't know whether it was 5, 10 people, or whatever. Later on, I found out that there were only the 3 members present at that. And what I have concerns with, so I didn't receive any response to that, but what I have concerns with is that I asked Mr. Kinsell directly these questions, which he was one of 3 people at this meeting. And what he did is he delegated my request to Mr. Lazar, and I received an email from the secretary of Mr. Kinsell on February 7th invoking a 14-day extension to respond to my request, claiming that he had to go through numerous numbers of documents and that it was going to take him so much time. But I asked Mr. Kinsell questions because I knew he had the answers to them. There was no need to do any search. There was no need to go to the city attorney's office, because in invoking the 14-day request as pursuant to the California Records Act, he stated that it was necessary to get advice from the city attorney. And what he did was he delegated the authority to Mr. Lazar. And then I got this email saying they want 14 days. And then on February 16th, I got an email from the Street Arts Program Assistant, Alicia Lycoris, saying that Mr. Lazar had been sick for a week and that he wasn't going to be able to respond in time. Now, according to the Sunshine Ordinance, and I forget exactly which section is it says that if the department head directs somebody to respond to a request and that person is sick and they can't respond, then the department head it says mandates that he appoints somebody else to respond to the request because the person he gave it to is sick. And so what I'm saying is that I feel that Mr. Kinsell violated the ordinance because he knew what the answers were. He had knowledge of these answers. He deliberately gave it to Mr. Lazar and then told him to research it. Well, all Mr. Lazar had to do was ask Mr. Kinsell what the answers were and send me an email right away. They didn't have to request a 14-day extension. He could have had his secretary send me an email, at least answering the verbal information, and then, as far as the draft documents go, ask for an extension on that. So what I'm saying is that he violated the Sunshine Ordinance by not providing me with this information within a reasonable amount of time.
Thank you.
And I'm sure you have questions.
Thank you. Is there anybody to present facts and evidence in support of the complainant?
Good evening. I'm Robert Clark. Yeah, to try to take it a little further, we did ask Mr. Kinsell directly. We addressed him because we knew he knew the answers. We never even knew. He didn't send an email back to us saying, well, look, I'm delegating it to Mr. Lazar. We didn't know that even Mr. Lazar had anything to do with it until a month later when Mr. Lazar sent us these answers, one of which we're not satisfied with. So we're thinking, well, in a day or two, this guy's going to send us an email, but we get this message from his secretary 4 or 5 days later, invoking a 14-day rule. So we accept it, and so the next thing I know is a month went by, and then we filed this complaint. And then the day, as it happened, the day after we filed the complaint, we get this letter from Mr. Lazar saying, well, here's your answers. I'm sorry it's taken me so long. I've been sick. And we're saying, wait a second. Mr. Lazar, Mr. Kinsell should have answered us right away. Mr. Kinsell, if he did delegate it to Mr. Lazar, he could have told Mr. Lazar the answers and said, Mr. Lazar, send an email over to these guys right away. Here's the answers that they asked for, 1, 2, 3. But he didn't do that. He let Mr. Lazar sit there, and then for like 2 weeks, Mr. Lazar is, quote, researching. And then all of a sudden, Mr. Lazar gets sick for another 2 weeks, and they don't delegate it to someone else to at least get us this information on time. And so we get this information a month later, and, it's just like, well, we didn't ask for a public record of the vote tally. We just asked what the vote tally was. He could call Mr. Lazar up. I mean, Mr. Lazar can call Mr. Kinsell up and say, well, what was the vote tally at the hearing? You, Jill Mantan, and Mr. Tum were the only 3 people there. What was the vote tally? And if Mr. Kinsell says, well, there wasn't a vote, then he could tell me there wasn't a vote. Because he could say, well, we just all sat around and we all talked about it. And at least I can get the oral information of how this money that we were talking about earlier, how they determined that this money, this $18,000, was going to be charged by the Street Arts Program. But they didn't do any of that. And I think this is a deliberate attempt by Mr. Kinsell to postpone answering any of my questions because he's refusing to answer my questions at public hearings. He's refusing to answer my questions through emails. He's passing it off to someone who doesn't know the answers, who he can tell the answers to in 5 minutes, and the guy could be calling me up and saying, here's the answers. But no, he makes us wait for over a month and then sends us this email. And, we're here in front of you today because this is how we're being treated when we try to get information from Mr. Kinsell.
Thank you. Is there anybody else to present facts and evidence in support of the complainant? Seeing none, is the respondent present? Thank you again for coming, sir. You have 5 minutes.
Thank you. I'm Julio Matos, representing the Arts Commission and Streets Artist Program, Director Howard Lazar. As a representative, I was asked to convey to you the following information relating to this case. According to your agenda, William Clark filed a complaint against the Arts Commission for allegedly refusing to respond to a public records request. We deny the charge. In our letter of March 14, 2011, to the members of your complaint committee, we explained that while there had been a delay in responding to furnishing documents, the Arts Commission did not refuse to respond to the request. Furthermore, our letter gave valid reasons for the temporary delay. Here's the letter if you wish to see it. On February 3rd, William and Robert Clark wrote to the Arts Commission Director of Cultural Affairs, Luis R. Kinsell, requesting answers to various questions in reference to the Commission's management team, its decision to levy a 5% administrative charge on the Commission's Street Artist Program. The Clarks also requested a rough draft of the minutes of the January 25th, 2010 meeting of Commission's Executive Committee. Mr. Kinsell directed Street Artist Program Director Howard Lazar to research documents appropriate to the Clark's request and to respond to it. Mr. Lazar immediately commenced to research. However, due to illness, he was out of the office for the better part of 2 weeks, and upon his return to work on February 28th, resumed his research relating to the request. During his absence, he requested his assistant to inform the Clarks that he was out of the office due to illness and that he understood that their request was to be fulfilled by February 17th. The assistant so informed the clerks by email. On March 2nd, Mr. Lazar responded in writing to the request and furnished relevant documents. A copy of this response was also furnished to the members of the complaint committee. Here's a copy if you wish to see it. Mr. Lazar's written response on behalf of the Arts Commission did three things. One, it fully responded to the questions submitted by the clerks. Two, it furnished documents relevant to the supervision charge of 5%. And three, it furnished the published minutes of the January 25th, 2010 meeting of the Commission's Executive Committee. In summary, both the response and documents were ultimately furnished by the Arts Commission. The delay in furnishing was due to the program director's absence from the office because of illness and is responding to workload which had accumulated in his absence. At no time did the Commission refuse to respond to the public records request. Sorry about this, you guys. I'm a little tired today.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none. Matters with the task force. Member Knebber.
To me, I think this is beyond what the complainant is even saying. I think this is a matter of minutes. Again, this is within that time. If this was a commission meeting, whether they voted on it or not, it should have been in the minutes, which should have been available in 10 days and available to the respondent, which would have had all the information that they wanted in those minutes. So, notwithstanding that there's an assertion, there's an assertion by the complainant that Mr. Kinsell could have responded in a couple minutes. Now, either way, I still think that the minutes should have been available within 10 days. They should have been able to get it and that would have been fulfilled their request.
Member Wolf.
I'd also like to point out that in both the letters, I think it's in both the letters, they had the Arts Commission had claimed that they had invoked a 14-day extension, but that's not provided in the Sunshine Ordinance. Only 10-day on an and was this an IDR?
No.
Either way, still 10 days.
10 working days. Same. So that's almost the same as 14 calendar days. Mr. Matos, please approach the microphone.
Yes, sir.
Is there a reason Mr. Lazar is not here tonight to answer questions?
I don't know tonight. I know that he usually, as I've said before, he usually takes care of somebody, usually after work, and he usually catches a bus to go home across the East Bay.
Is there a reason he couldn't have sent an assistant or somebody else who could really answer questions that we might have?
On this matter, no.
Thank you. Oh, one other thing, Mr. Matos.
Yes.
Is Mr. Lazar a one-person staff?
No, he has an assistant as well.
He does?
Yes.
So, in his absence, if somebody puts in a request for public record of some sort, the assistant would be the one responsible for getting that public record?
I don't actually have an answer for that one.
Okay, thank you. At this time, I'm sorry, Member Johnson?
No,
At this time, the respondent and then the complainant will each have 3 minutes to give any concluding or rebutting remarks. Mr. Matos? Mr. Clark?
Yeah, just a few things. One, again, I disagree with Mr. Lazar. He did not respond to my question number 3 about the vote tally. I still don't know what the actual vote tally was. And then the other thing, one thing I'd like to read you is just that this letter that was sent to me where This is what it says. The Art Commission was invoking an extension of not more than 14 days from February 3rd, 2011 to respond to your request pursuant to the California Public Records Act. That because there is a voluminous amount of records, the Art Commission staff must search through and examine to determine if it has responsive records, and Art Commission staff will need to consult with the City Attorney's Office regarding your request, and that the Commission will endeavor to respond to you as quickly as possible and no later than February 17th, 2011. I didn't get the response till March 2nd, I believe. And you know, in this request, there was no documents. I only asked for copies of the minutes of the executive committee meeting. Now, that, just to make it clear, that's different than the management team meeting. The executive committee meeting was regarding the street artist budget, which took place a year previously and had not been posted, and I wanted to get those minutes to find out what had happened. But the questions that I asked, Mr. Kinsell had direct knowledge of that information, and I believe the Sunshine Ordinance says that if an employee has knowledge of a question, that they're required to respond as quickly as possible. There's no reason for them to invoke a 14-day extension regarding a verbal request for these answers, and there was no reason for Mr. Kinsell to delegate this to Mr. Lazar. And when Mr. Lazar did get sick, then he should have delegated my request to Mr. Lazar's assistant or somebody else. This was not complicated. All Mr. Kinsell had to do was tell someone the answers to my questions and then send me an email. At least I would have had that portion of the request covered. And then regarding the minutes, what had happened actually, which is interesting, was right after I made this request, the minutes were posted on the Art Commission's website. And so these minutes hadn't been posted for over a year. And then after I asked for these minutes, they get posted, and then Mr. Lazar sends me this response saying, well, I'm sending you these minutes. So all I'm saying is, as I believe Mr. Kinsell violated the Sunshine Ordinance by not responding within a reasonable and appropriate amount of time to my questions.
Thank you. The matter is back with the task force. Member Wolf.
Mr. Matos. Can you explain to me who sits on the management team?
Who sits on the complete management team?
How many management teams are there?
There's a big list of the management team that you're referring to is a big group of people that are there. So now, are you referring to the directors?
So hold on a minute.
Yes.
Take 2 steps to your right. Mr. Clark? Yes. Which management team were you trying to get information from?
The only management team I know of is Mr. Kinsell's management team, which consists of 4 people.
Okay. Mr. Matos, can you speak to that, please?
Okay, so this particular the team that he's referring to is actually heavily related to the last topic that we spoke of, right? 10074. I think that is what you were referring to. Yes, I do know who the individuals are.
Are they all? I don't need to know who they are, but I need to know: are they all employees?
Are they all employees? They're they're directors. Pretty much.
Are they employees of the city and county of San Francisco?
Yes.
Okay. So, So, thank you.
Okay.
So, that does not make this a passive meeting. It's exempt from sunshine. Under Section 67.4A5, in the last sentence, it says, this subsection shall not apply to a committee which consists solely of employees of the city and county of San Francisco. This is the section describing passive meetings and their duties. Since this management team is not, it only consists of employees, then it doesn't apply. So the only item that we can actually speak to is the draft minutes of the Arts Commission of January 25th.
Member Knebber?
I would have to agree with Member Wolf. However, when we talk about the minutes, again, I'll bring it back to my point from before. The minutes should have been available long before they were, and I think that the information in the minutes would have given the information to the complainants that they wanted.
Through the chair of the commission itself?
Yes.
Okay, thank you.
Is there a motion?
I move we find violation of 6716.
Is there a second?
I'll second it, but if we include 6725. Immediacy of response.
Well, I see. I think that's through the chair. I think that's a separate issue again. I think the idea is, if they're exempt, we can't do.
No, there's only they made a request on two bodies. They made a request on the management team, and then they made a request on the commission itself, minutes for the commission itself. So, according to the only thing I have to go on is the complaint that was submitted through the task force website.
Okay, I'll accept.
Yeah, it says
And the chair would propose a friendly amendment to add 67.21E.
I would accept that too.
Likewise.
Maker and second both accept.
And referring it to.
So again, this one's difficult because education obviously isn't helping.
Right.
From a teacher.
Yeah, exactly. I'm at a loss. I think the thing I would say would be ethics.
And who are we sending to ethics?
Well, that's touchy too. I would have to say that.
Well, it has to be Mr. Cancel because it's the only person who's noted as being the contact.
Yeah, I guess so. Because even though it was Mr. Lazar who took a long time, it was Mr. Cancel who was asked the information, and he was given the information.
I think we have to determine who is the custodian of record. That's what we have to determine here.
Or, through the chair, Mr. Cancel is the department head, right? And it is his responsibility to make sure that information is out of there.
Okay. Here we go.
Member Washburn.
But this matter is actually against the Arts Commission.
If you look on page 164, you'll see the original submission, and it says Department, San Francisco Arts Commission contacted Louis Cancel, Director of Cultural Affairs. That's the person.
On page 165.
Yeah, on page 165. That's the custodian record.
Is there public comment on this matter?
There is. David Pilpel again. Just to provide some historical context here, I recall that prior to Mr. Cancel, actually I cannot recall a complaint against the Arts Commission prior to Mr. Cancel. I don't know him personally, but I do recall that a couple of years ago in the budget, there was a deputy director position held by Ms. Nancy Goncher. That was eliminated, and she was laid off, separated from city service. I think that she was probably the designated person that was handling sunshine matters at the time, and so things went a lot more smoothly. In her absence with this restructured management team, that does not include Ms. Paige Ritchie, who's the commission secretary and probably one of the longest-standing staff members over there. She would be well-placed to be their sunshine contact. She is apparently not their sunshine contact. They're not a large department, and a number of the complaints that have come before the task force in the last several years involve the street artist program and some of the difficulties with funding and administration of that program. We've heard this similar matters several times before. I would suggest, regardless of how you dispose of this instant complaint, that you seek to have a discussion with Mr. Cancel in some fashion about Ms. Page Ritchie and that possibility, and that you advise the complainants that with respect to the street artist program and the fees and how that's handled, that the Budget and Finance Committee of the board and the Controller's Office with respect to fee setting are good avenues for them to pursue, not necessarily avenues for the task force, but avenues for the complainant to pursue. I want to be careful that I don't think complaints about program administration are properly before the task force, but complaints about records and lack of providing timely responses to records requests are properly before the task force. And where you have, it seems fairly obvious, a pattern in practice, you should try to get that corrected by having a designated sunshine person or custodian of records who has as much wherewithal to deal with that and subject matter expertise and tenure so that they understand the full range of things before the agency. Although this is against the Arts Commission, it's really, I think, more against the Arts Commission staff than the Arts Commission itself. Unless you have questions, thank you.
Thank you. Is there further public comment on this item? Seeing none, public comment is closed. Is there further discussion on the motion? Member Johnson.
I just would like a little bit of clarification, perhaps from Member Wolf. Are you the request for information was sent to Mr. Cancel? Are you saying that because the information was about a meeting that was not a passive meeting, that information is not subject to the Sunshine Ordinance?
If you look on page 165, in the first sentence, under description, the complainant states, on February 3rd, 2011, I sent Louis Cancel an email, which posted below, requesting some public information and for a copy of the minutes or an audio cassette copy of the 7/28/10 meeting of the Arts Commission Management Team and for a copy of the draft minutes of the Arts Commission's January 25th. So it's for two separate bodies. One body is the management team, the other body is the Arts Commission Executive Committee meeting. So what I'm excluding the management team because it's not a passive body.
But if you look on page, if you look on page 170, when they respond, they say, in your request, you've asked the following questions to which we respond. What are the names? Who attended? And these were directed to Mr. Cancel. Are you saying that that's not under the Sunshine Ordinance because it's not a passive meeting?
Right. When you look at he says, what's the names of the people comprised of the management team? And he answers, it's comprised of himself, Louis Cancel, Jill Manton, Sansan Wong, and Can Kutun. They're all employees of the City and County of San Francisco. If they meet together, not sunshineable.
Right. The meeting's not, but is that information?
No.
The names of the people at the meeting are not as well.
Well, but that's not what he asked for. He was asking for a copy of the minutes.
Is that the only thing that you asked for? A copy of the minutes?
I wasn't asking for a copy of the minutes of the management team. I asked for a copy of the minutes of the Executive Committee of the Arts Commission.
According to your submission online, it specifically says, requesting some public information and for a copy of the minutes or an audio cassette copy of the 7/28/10, July 28th, 2010, meeting of the Art Commission's, quote, management team, unquote, meeting.
That's correct.
Well, That's what we're. That's
That's correct. I did ask for that, and they told me they didn't have any.
Right. Well, the question that Member Johnson is asking is whether the information based upon your questions are part and parcel.
The questions I asked were just the names of the.
He didn't ask for only the minutes. That's just his description of the complaint. Otherwise, he asked specifically for the names of the people who are on the management team, and then he asked for who attended. And I think that's public information. I don't understand why that would, the meeting itself, but I don't understand why that wouldn't be public. I mean, we when they asked the city attorney the same thing in another case, we ruled that that was public information that they could provide orally. And since Mr. Cancel was there, he could have provided that orally, which I think violates 6722.
So you're separating the questions from whether they need to follow sunshine with regards to their meeting.
Well, I'm asking if their meeting of the management, if the names of the meeting are also, I'm asking your, out of your experience, are the names, just the names, also something not subject to sunshine? That seems like, even though you can't get anything out of the passive meeting body itself, I don't understand why the actual information isn't public, the names and who attended.
I would hold that it probably is public.
So I would.
I mean, it may or I would probably hold it is. Who meets. What do they do? That kind of stuff.
So I would suggest that
as far as requesting any specifics about what did they discuss on this particular day, and are there any minutes, and what their votes are, that's not sunshineable. They're not required to follow sunshine.
Nothing in the meeting is required, but the actual, you could ask who and. Who are the people that consists of the team and who attended the meeting? Mm-hmm. You could ask that, and they did indeed ask that. And I would suggest that Mr. Cancel had that information. So he's in violation of 6722A and B. It was an oral information that he could have provided to them right away. Instead, he sent it off to Mr. Lazar and had him research it. And 6722B says the role of the person or persons so designated to provide information by the department head shall be to provide information on as timely and responsive a basis as possible to those members of the public who are not requesting information from a specific person. So Mr. Cancel had no reason to provide it to Mr. Lazar when he could have easily just stated it since he was one of the people.
Good catch.
In addition, I just want to point out one quick thing. I know it's late and I know it's annoying, but on page 169, when the clerks brought us to, for future reference, when the clerks came to us complaining that the Board of Supervisors approved charging an additional fee to the street artists specifically for the Sunshine Ordinance, one of the things that I was very concerned about was that they would hold it over them like a threat. And I would like to point out to you that in their San Francisco Arts Commission March 2nd letter, they say, Arts Commission staff will need to consult with the city attorney's office regarding your request. That doesn't seem like a threat to us, but when you're a street artist and you know you're going to have to pay for that, that is something that is going to continually, they're going to throw in their face.
I'm sorry, where is that located on the page?
169.
Yeah, but where on the page?
In the first paragraph, 3 sentences up. And I think that is, with our knowledge of what goes on, I think that is an unveiled monetary threat to the street artists. So in the future, I really think we should reconsider when someone specifically says they're going to charge people for the Sunshine Ordinance, it definitely gives them the ability to throw something out there. Remember, they went before the Board of Supervisors and specifically said they were raising the street artist fee for responding to the sunshine ordinance, and they had a city attorney fee up there, and we said we couldn't necessarily say anything about it. But one of the concerns when you do that is they know they're going to have to pay for that every time they ask for something. But that aside, I would like to make a friendly amendment to add 6722A and B.
I'm okay with that.
Further discussion? Is there public comment on this item? Seeing none, public comment is closed. Roll call, please.
On the motion, Member Cotton?
Aye.
Cotton, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber? Knebber, aye. Member Costa? Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 9 ayes. The motion passes.
Thank you. Could you read item 20, please?
Item number 20 is determination of jurisdiction on complaint filed by William Clark against the Arts Commission for allegedly refusing to respond to a public records request.
Second.
Second.
Moved and seconded. Is there public discussion on the jurisdiction question? Seeing none, public comment is closed. Roll call, please.
On jurisdiction, Member Cotton? Aye. Cotton, aye. Member Manny?
Aye.
Manny, aye. Member Washburn?
Aye.
Washburn, aye. Member Knebber? Knebber, aye. Member Costa? Costa, aye. Member Wolf?
Aye.
Wolf, aye. Member Chan? Chan, aye. Member Johnson?
Aye.
Johnson, aye. Member Nee?
Aye.
Nee, aye. Mr. Chair, we have 9 ayes.
Okay, before we proceed with the substance of the complaint, it should be noted that Mr. Threet has departed. 9 o'clock is his deadline because of the restrictions on his time. That leaves us without an attorney tonight. Do we want to proceed on this item?
I move that we proceed.
Okay. Mr. Clark, do you have any objection to our proceeding without an attorney present?
No, I don't.
Mr. Matos? Okay, Mr. Matos has indicated no objection. In that case, we will proceed with the merits of the case. Mr. Clark, please. Again, thank you for coming, and you have 5 minutes.
Thank you for bearing with all this. I would like to. This case involves me being given a videotape cassette by Mr. Lazar. An audio cassette recording of the meeting of the Arts Commission, which took place on January 12, 2011, of the Street Arts Program Committee. I was given I would like to give you this affidavit by street artist Eddie Stanek, because I assert that this is not a true copy of the audio cassette copy I received. I assert it's not. I don't accept it. It's not a true copy of what took place at the meeting. There are portions of the meeting that have been deleted from this tape. At the meeting, under public comment, we were discussing the budget, and my brother stood up and he made a statement saying that he had a few questions regarding the figures in the budget. And at that point in time, Mr. Kinsell stood up, reached across the table, and pointed at my brother and shouted at him and told him, "You are not allowed to ask questions under public comment." And my brother said, "Yes, I am allowed to ask comments." And Mr. Kinsell said, "You're not," he made a comment like, "You're not allowed to ask questions. You're only allowed to make comments. And if you ask questions, we're not going to answer them." And my brother said, "Well, I'm going to ask the questions anyway. If you don't want to answer them, that's up to you." And then Mr. Kinsell said, "So you're under public comment?" And then my brother proceeded with his public comment and answered him. And I was sent the cassette copy I received. I received three copies of it. I received a digital copy by email by Mr. Kinsell, which the quality was so poor I could barely hear it. And I also received a CD copy in the mail from Mr. Kinsell, and that was so poor that I could hardly hear it. So I asked Mr. Lazar. So I asked Mr. Lazar to allow me to go down to the Art Commission's meeting and listen to the original tape of the meeting to inspect the tape. And when I went down there upon inspection, all the portion where Mr. Kinsell yelled at my brother was not included in the tape. Now, like I said, I have a statement from another person who was at that meeting in which he says that he heard Mr. Lazar yell at my brother and tell him that he couldn't ask any questions. And I take this very seriously because this tape was altered and it is being purported to be the official meeting of the Art Commission at which Mr. Kinsell made these remarks. And those remarks were deleted purposefully, and now I'm being told that this is what the meeting is. Now, what that does to me is that says I'm a liar. That says my brother a liar, that we told you before we made this request that this incident happened, and now we're being given this official record that this portion of the meeting is deleted. And I don't know exactly what to ask you to do, except I think this is criminal. I think that this is something that should go to the DA or something because they're altering an official record of the city and county and giving a misrepresentation of what actually took place at that meeting. And I do have copies of these things which I'd like to present to you. I wrote up some transcripts, which I don't have time to read it all now, but I would like to present this into evidence to you that, so that it will be on the official record. Thank you. And I just wanted to say in closing that under the Sunshine Ordinance, it says that a policy body shall not abridge or prohibit public criticism of the policies, procedures, programs, or services of the city, or of any other aspect of its proposals or activities, or of the acts or omissions of the body, on the basis that the performance of one or more public employees is implicated. And then it says, or on any basis other than reasonable time constraints adopted in the regulations pursuant to subdivision C of this section. And the fact that we were told that we were not allowed to ask questions, even if they're questions, criticism in the form of questions, I think violates our rights and violates this section of the Sunshine Ordinance. Thank you for your time.
Thank you. Is there anybody to present facts and evidence in support of the complainant?
Hi, I'm Robert Clark. First of all, we do have a copy of the tape with us. We can present to you. It's late, so I don't know if you guys feel it's necessary. I don't think it really is necessary, but we can present it to you if you want to listen to it later on yourselves. We'll be more than glad to give you that section. And since it happened to me personally, I want to testify that I did go up there. I did say I have a few questions on these figures. Mr. Kinsell jumped out of his chair, leaned across the table, pointed his finger at me, and yelled at me that you are not allowed to ask questions under public comment. I was shocked, and I turned to him. I said, well, yeah, I am. And he said, no, you are not. You are only allowed to ask comments. You're only allowed to make comments, excuse me. So what happened is we waited till the minutes of this meeting was posted at the Art Commission. And when we read the minutes, it said in the minutes that Mr. Robert Clark would ask several questions. I thought, now, wait a second. That's not what happened. Mr. Kinsell told me I couldn't ask questions. So that's when we requested a copy of the tape, because I thought something strange is going on here. And when we did get a copy of it, sure enough, the whole section where Mr. Kinsell yelled at me was totally deleted out of the tape. And if you listen to the tape, you can understand it, because it doesn't make sense. The chairman tells me, okay, we're under public comment now. I get up and I start to speak under public comment, And the way the tape goes, all of a sudden, Mr. Kinsell jumps up. Mr. Kinsell says, "You're under public comment." So that's the only comment they had on there that Mr. Kinsell said to me. And in reality, what had happened, Mr. Kinsell had yelled at me for, it took me, there was like a minute or so where we were arguing back and forth about how I do have a right, until eventually I said, okay, I'm going to ask these questions anyway. If you don't want to answer them, don't answer them. And that's when Mr. Kinsell said, "You're under public, so." So what they did is they cut out that whole section to make it appear like that never happened. And so personally, I think that at the very least, we did not get the true copy of this meeting that we requested, and that's the complaint that we're coming to you under. But I do think that this is a very serious matter here. This goes beyond refusing to give information or delaying information. When our public bodies literally go out there and change public records, then how can we even respect our public bodies? I think this is a criminal act, and I don't know where. Maybe I'll go down and file a complaint with the DA myself if you guys can't do anything. But thank you for giving me this time.
Thank you. Is there anybody else to present facts and evidence in support of the complainant? Seeing none, respondent, please. Again, thank you for coming, sir. You have 5 minutes.
Thank you. Of course, I'm Julio Matos, representing the Arts Commission and Streets Artist Program, Director Howard Lazar. As a representative, I was asked to convey to you the following information relating to this case. I was specifically asked to read to you the following letter by Mr. Lazar. Dear Task Force members, with regard to the audio recording made by the Arts Commission of the January 12, 2011 meeting of its Street Artists Committee, the complainants have stated, according to Deputy City Attorney Jerry Street, that after listening to the tape, they determined that this was not the original tape recording of the January 12, 2011 meeting. Based on the absence from the tape of Robert Clark's public testimony at that meeting and the response to that testimony by Director Cultural Affairs Louis Council, and due to this, complainant does not accept that he has been provided the full, unredacted version of the public records that he requested. In response to these allegations, we herewith submit to you the entire original recording which was made of the January 12th, 2011 meeting. Furthermore, we wish to present you with the following facts. This is the original recording of the meeting. Only one copy of it was made by the Commission, and it was made in the format of computerized audio file by connecting the Commission's tape player to a computer. The entire recording is comprised by these two original audio tapes that you see before you. There are the entire unredacted version of the public record. These two original audio tapes, as well as their audio files, which were sent to the Clarks, were not redacted. No blanks occur anywhere in these tapes. No splices occur anywhere in these tapes. Full sound is recorded in its entirety on both sides of the first 90-minute tape and on the first side only of the second 90-minute tape. The first side of the second tape recorded the adjournment of the meeting with the bang of the chairman's gavel. The second side of the second tape is blank, as meeting had ended on the first side. According to their audio files, these two original tapes comprise a total of 138.2 minutes, or 2 hours and 18 minutes. This is closely reflected by the official minutes taken of the meeting, which reflect that the meeting started at 3:05 p.m. and ended at 5:22 p.m., hence comprising 2 hours and 17 minutes. The allegations by the complainant that there is an absence of public testimony by Robert Clark and a response to that testimony by Louis Council is unfounded, because this original recording, which was given to the Clarks for their own duplication purposes, reveals clearly the questions directed by Mr. Clark to Mr. Council, as well as Mr. Council's response. There is no redaction of any Mr. Clark's questions nor of Mr. Kunzel's reply. The only instance in which the recording did not fully record testimony by one of the Clarks, whom I cannot identify, is when side A of the tape 1 ended automatically while Mr. Clark was addressing the issue of a proposed lottery procedure for the assignment of street artist spaces. Although he was signaled that the tape had stopped, he continued talking while the tape was being turned over to side B. After the running of the tape's blank leader, side B recorded the resumption of Mr. Clark's comments. In a similar fashion, side B of tape 1 automatically ends while street artist Michael Adario is commenting, and Adario's comments are then resumed after length of blank leader on side A of tape 2. We encourage you to listen to this entire original recording of 2 hours and 18 minutes. Should you decide to listen to it away from your public meeting, we will demand that the tape be played in the presence of a staff member of the city attorney's office. This entire unredacted, unaltered original recording of the meeting was given to the Clarks at the Office of the Arts Commission in compliance with their request to duplicate themselves on their own recording apparatus. They took the tapes into a room we provided, they closed the door of the room, and we were unable to observe what they chose to hear. As custodian of the tapes, I listened to the tapes in their entirety in order to verify that they had not been altered. Again, what you have before you is the entire unredacted, unaltered original recording of the meeting. There is no evidence of redaction of Robert Clark's public testimony and the response to that testimony by Director Cultural Affairs Louis Kunzel. There is no evidence whatsoever of any redaction of anything that was recorded. The Clarks were provided with a full, unredacted original version of the public record they requested. They were provided with it in both its original recording and in its audio file of the recording. Therefore, we respectively request that you dismiss the charge. Sincerely, Howard Lazar, Street Arts Program Director.
Thank you. Is there anybody to present facts and evidence in support of the respondent? Seeing none, the matters with the task force. Member Wolf.
First of all, I don't approve of testimony by proxy. This is, to me, is really outrageous. And if I had the ability, I would say delete it from the record. I don't accept it. If they can't show up to give something that explicit for something this quote-unquote sophisticated for them, then, they should be found at the highest level of in violation. It's ridiculous.
Mr. Matos, please. The meeting that's under consideration here, under discussion, is a recording of that meeting available on the web?
Yes.
It is?
Yes.
So if one or all of us wanted to call it go home and listen to it on the web, we could do that.
Yes.
Okay. Thank you.
Okay.
Member Kneber?
Now, this is in absence of listening to the tape, this is kind of a they said situation, although I am, of course, leaning towards the complainant because of the history here. But even with that, it seems a little bit far for me to conclude that the tape was concluded. I mean, it was redacted or cut up or whatever at this point. So I don't know where we're at.
Member Johnson.
One of the Clarks would, I guess, to start with. You're saying that they sent you a copy of the tape, and it was inaudible, too difficult to understand.
Difficult.
And so when you went to listen to the original, was that the original that they?
That, I believe, is the original.
Is that what they let you listen to?
Yeah, I listened to audio cassettes.
And so you're saying that when you listened to that, there were portions that were not
That's correct.
That were not there.
That's
Okay.
correct.
And then, Mr. Matos, the letter that you read, it went into some detail about times. So
Yes.
is the point of that letter to say that that's the original tape, it's always been the original tape, and no
Yes.
portion other than the leader
Yes.
is missing?
Yes, pretty much what the letter states is that when Mr. Clark was actually replying, when he was still commenting, the letter states that he was actually informed that they're replacing the tape right now. So hold on for a moment, but what it's stating that he still was talking even though that they changed the tape and it started recording once he resumed.
And
That's pretty much what the letter.
And these are cassette tapes?
These are the cassette tapes that they recorded.
But they've been placed on the web.
I do believe so. I have to reiterate that, as one of the clerks said, actually just mentioned to me that it may not be on the web, but I do believe that it is.
Mr. Matos?
Yes, sir.
Presumably, then, if it's on the web recording would have been made from something other than tape, right?
Not necessarily, because it's actually, pretty much how it's actually recorded is actually through being connected online. It's through a computer. It's like a teleprompter.
Well,
It's not tape.
What I'm getting at then is that presumably the gaps that occur on the tape would not occur in the online version in the online recording, correct?
True.
Okay.
But I'm not too familiar with what their recording methods are over at the San Francisco Arts Commission. So I'm just letting you know that pretty much I watched Mr. Lazar actually record these. I was over there the day that he did it.
Okay.
Okay.
Did you witness the incident that the Clarks are referring to?
No, I was not there when they came over there. They just came over there, I think, earlier yesterday.
No, did you witness at the meet? You said you were at the meeting when this was being taped.
not the meeting when it was being recorded.
Oh.
I was at the meeting. I was actually I was there when Mr. Lazar was recording it onto these tapes.
Recording onto these tapes from what?
From his computer. His computer was playing. This was the last meeting that I was here.
But the letter said that the leader has pieces missing. So if he was recording from it, how did the leader get missing?
I don't know about the leader. As I said, I wasn't there when they recorded this. I was there when Mr. Lazar was recording it from his computer onto these tapes. That's what I'm saying. I'm not saying that...
But the letter says that Mr. Clark was informed that the tape had to be changed at the meeting. But if it's from a computer...
No, I watched Mr. Lazar download these two. I was there when he was downloading this from his computer onto the tapes that you see before you.
Do you know how the meetings are recorded?
No,
Are they
I don't.
recorded on these audio tapes? You
I
don't know?
do not know.
Thank you.
But I could come up with an answer.
I know we found multiple violations, but just on the back of your head, one thing I think we might want to consider is to continue it to make Mr. Lazar appear rather than continually sending it to ethics. This is outrageous.
Yeah.
Member Costa, Member Washburn, Member Wolf.
Can I clarify something with you, Mr. Clark? When you originally heard, you heard how many versions of the recording?
I heard 3 versions.
Okay, and can you just clarify what formats all 3 of them were in?
The first one was on my computer. It was just digital. I tried to play it off my computer, and it was so low I could barely hear it. Second version was 2 CDs that I received that I could barely hear it. And the third version was what I was told was the original audio cassette tapes of the meeting, which the meetings are taped on audio cassettes. Now, apparently Mr. Lazar downloaded this I said this was the original version. If he downloaded this off of his computer, then this isn't this is not the original version of the meeting. And I just want to clarify, my brother So the portion that we're claiming is missing was not at the end of the tape. It actually is in the middle of one side of the tape, the portion that's missing.
And when you listened to the tape, was anybody else present besides your brother?
No, just my brother and I were present, and I had a video camera, which I videotaped. I went after I listened to it. I went in and objected to this, and I put all that on videotape. But nobody else. They reserved the room for me at the Art Commission, provided me with a small cassette player. I had my own cassette player and duplicated with me because I intended to duplicate it. And when we locked the room behind us, nobody else was there.
But you also have that listening session on videotape.
That's the portions of the tape that I have with me tonight. I just taped the portion of the tape that's in controversy right now. I didn't tape the entire tape. I just taped the portion that where the missing testimony is.
Member Washburn, Member Wolf, Member Johnson.
Mr. Clark, I'm really still very confused about the media that's being used here to record this meeting. So when the actual meeting happened,
right?
How is it recorded?
It's recorded on an audio cassette like these, just a regular audio tape player.
Okay. So in fact, there was a point where the tape had to be turned over, and perhaps some audio was lost.
Right. Some audio of the meeting was lost, but not the audio where my brother testifies. The portion where my brother testifies is in the middle of the tape, and I'm sure it's even in the middle of these tapes too. When he testified, they didn't flip over. It might have been later on the meeting because I also testified, and as he said, he doesn't know which one it was, but they may have turned it over later on when I was testifying. But the portion that we're saying is deleted was not at the end of the tape. In fact, it's in the middle of one side of the tape. So there's no way he could have turned it over and lost any portion of Bob's testimony.
Okay, so at the meeting was recorded on the cassette tapes, and then there was a digital version made for the computer off of those.
Right, which I got sent.
Right, and that's when you noticed, or you suspected.
Well, that's when it was so poor that I didn't want to rely on that. And he also sent me a CD copy of it, which was also very low. I mean, too low I could barely hear it. So that's when I asked to inspect the actual original cassette copies, and then we went down to their office, and they gave us the cassette copies, which we listened to on our own cassette player. But the meeting was actually originally taped on audio cassette. So it's very possible that a portion of the tape could have been, and transferring it from audio to digital, that a portion of the tape could have been deleted. And this was not, like I said, this portion was not in the middle of the tape. Excuse me, it was in the middle of the tape. It wasn't at the end of any of the tapes.
Okay.
Member Wolf, Member Johnson.
One thing, I have access to the internet, and there are no audio recordings on the Arts Commission page. Second of all, just for everybody's edification, very, very few, if any, minutes are posted from previous meetings. Some of the agendas are there, just so you know. The other aspect is if we want to consider, the evidence that pertains to this particular complaint is all on recorded medium of some sort. If we really want to give respect to the complaint and we consider the gravity of the violation, then I think we should give some time to be able to review the tapes, especially if one set of tapes has the omission and another set of tapes has what has been omitted. Then you have the full record. And that's what, to me, it's an amazing opportunity to be able to piece it all together and really hear what's really happened and what really went on. So I would say, if it would be, I think, with respect to the Sunshine Ordinance and to the complainants, to continue. Let us all get copies of all the evidence that is here, and let's listen to it and make a proper have the proper deliberation and a ruling.
Member Johnson, Member Kneber.
Mr. Clark, William Clark.
William.
Are you saying that when you listen to the tape in the middle of it, there's suddenly a blank spot?
No.
Or it just jumps from one?
It goes from my brother saying, I have some questions, short pause. I have some questions about the figures, short pause, slight pause, and then Mr. Kinsell says, so you're under public comment. You're under public comment, so.
And so there's no, you're
But
saying that there's
a portion deleted between when my brother says figures, and then there was the whole discussion went on, and at the end of it, he was saying to my brother, you're under public comment, so don't ask any, the implication at the time was, you're under public comment, so don't ask any questions. That's why he said you're under public comment, so.
But he did ask questions in between the time he said, don't ask.
My brother, my brother said, I have some questions about these figures. Mr. Kinsell jumped up, pointed a finger at him, yelled at him, and said, you're not allowed to ask questions under public comment. My brother responded by saying, yes, I am allowed to ask questions. Mr. Kinsell said, no, you're not. He said, you're under public comment. You can only ask questions under public comment. Excuse me, you can only make, I'm sorry. You can only make comments under public comment. And my brother said, that's when my brother said, well, I'm going to ask these questions anyway. If
So
you don't,
all of that is
yeah, that's all gone.
Okay.
And
the only other thing that is a little bit of a concern is that the Clarks were locked in a room with the tape, the original tape.
What
So
was locked in the room?
The Clarks, were
oh.
locked in the room with both of those tapes. It's going to, unless the digital version is different too, who's
We
going to
need
know
to-
who erased it?
We need
Not
all
that
of
they
it.
would erase it. I'm just saying.
We can't even blame this on Rosemary Woods.
except that the digital version that I was sent to on CD is the same as the version he's giving you right now.
Do you still have the CDs?
Yes, I do.
Okay, so we could potentially do your.
So, I'm sorry, Mr. Clark. I'm sorry, Mr. Chair, if I might.
Member Wolf.
Mr. Clark, the what you have on CD has that exchange between Mr.
No,
Kinsell?
it's gone.
Okay, but I thought what Mr. Matos had presented us was the original tapes that would have it.
Well,
Would not have it.
he's claiming those are the original tapes, and those still have don't have the portion. that-
Okay, but you have a separate recording that you did on your own.
No, I have the digital copy which was sent to me in the mail before I went down to listen and inspect the original copy, and then we were allowed to be put into a separate room, just to say that. So the version I have on CD, which was before I went to listen to the original version, will be the same as that version right there.
Okay.
So
But I thought either you or your brother said that you had your own tape recorder.
No, we didn't.
No?
No, we didn't tape record the meeting.
Okay.
I have. Why would I tape? I mean, to say.
Didn't one of you say that
through the
you
chair? What he said
Member
was he
Kneber.
had his own tape recorder when he went down there to record the
I see.
portions that he wanted.
Okay, but it wasn't during the meeting.
Yes.
Okay,
No, it
gotcha.
wasn't
So we
during-
don't even. There's no record.
There's no way to do it.
Okay.
Under my comment, before you continue, if you decide to do that, will I get a chance to just make my short response to the rebuttal?
You will.
Okay.
Yes. Mr. Chair, I'm
Member
also
Wolf.
wondering if maybe the testimonials that were passed around, whether that might also lend any, though those people aren't here, they're written, but I'm wondering if that might also lend
Well,
any evidence.
since we are apparently going to be continuing this matter, they can be included in the information packet for the next time. Member Knebber?
If we do continue, I would like to devote some time in the next time we bring up this case to actually listen in here in the meeting to those sections that are disputed.
Right.
Instead of just doing it at home, I'd feel much more comfortable of all of us
Here.
listen to it together in public forum as opposed to us doing it on our own. That's fine if we do it on our own, but I would rather, I feel much more comfortable as part of the public meeting, listening to it in public meeting.
I'm cool with that.
Member Coffin?
Mr. Clark, does that cassette contain the interchange between you and Mr. Kinsella?
No,
about
this
questions?
no, this like in response to what he was
But
saying.
it is gettable. It's not.
Yeah, this is hearable. This contains, rather than you having to listen to the entire meeting, which is all about other things. This contains the segment where the 5 or 10 minutes where this deleted portion took place. So I mean, I can provide you with the CDs of the entire meeting that I received, as well as you have these, and I can give you a copy of this so that you don't have to listen to the whole thing.
I think that we should listen to it next time, and you can move it forward to the place where it occurs, right?
Right.
Okay, good. Right. Thank you.
Member Johnson?
Mr. Matos, do you have any idea if Mr. Lazar, was it Mr. Lazar or Mr. Kinsella you had the exchange with? Mr. Lazar?
I had the exchange with Mr. Kinsella, but Mr. Lazar was present at the meeting. Okay. And later on in the tape, when you listen to it, you'll hear Mr. Lazar and Mr. Kinsella respond later on after I ask the questions. They vehemently say, we are not under any obligation to answer any questions. So both of them
okay.
At that
well,
time.
What I'm wondering is if either one of them, if either one of them contests that this exchange ever happened. I'm asking Mr. Matos.
Oh.
Do you know if Mr. Lazar or Mr. Kinsella?
I don't know. But of course, if we're going to be continuing, I will find out.
Well, I would prefer that one of them came here to tell us.
No, I'll actually. I have to reiterate everything that actually happened tonight anyway to Mr. Lazar, so I can actually.
Can you also reiterate that while you're reiterating, that's why it's a problem that they don't come here?
Yes.
Thanks.
Okay.
Member Costa?
Mr. Montes, one more question for you. You said that you saw Mr. Lazar make this tape, and I was just wondering if you could say exactly when that happened.
This was actually, let's see, when was the last time we met here? I forget.
It was. That's a good question.
I
wasn't here. So at the last meeting.
It's the last meeting that we were here. It was actually only a few weeks ago. I think it was March 8th or somewhere around there.
Okay.
At any case, that was the day that I seen it.
At this time, the respondent and then the complainant will each get 3 minutes to make any concluding or rebutting remarks. Mr. Matos? Mr. Clark?
Okay, I just want to read this into the record. This is the statement made by Eddie Stanek, who also attended the meeting. It's dated 3/21/11. To whom it may concern, I, Eddie Stanek, attended the January 12, 2011 Street Arts Program Committee meeting. During item number 2, when Robert Clark began speaking about the fact that he had some questions about the figures regarding next year's proposed budget, I saw Mr. Kinsella interrupt I saw Mr. Kinsella interrupt Mr. Clark's public comment and tell Mr. Clark that he could not ask any questions under public comment. So, I mean, he is a witness, and I may be able to bring him into the next meeting. But, I know that this statement, if sworn under penalty of perjury, would be evidence that it would be a valid affidavit, which you could consider as evidence to support my claim. And I just want to reiterate that apparently the cassette copy you have there is not the original copy. And, you know, I feel that you should, if anything, you should request the original copy, because this was downloaded off of the digital copy. And as I said before, the CD versions I have, I will assert that they are the same as that. And there's no way that if they're claiming I erased the tape, that this is supposed to be the original one, there's no way that I would have a CD version that has the portions deleted. And I think that we also can present you with evidence to show that not only was this cassette doctored, but the minutes themselves of this meeting have been false. There are portions of the minutes of this meeting that claim that there was a disruption that occurred, and that the committee had to make a public announcement that if there was another disruption, that the people would be escorted from the building by the San Francisco Police Department, meaning me and my brother. And this cassette will show that never happened, but it's in the minutes. And Mr. Lazar writes these minutes. And so I feel that I can impeach his testimony by showing you that he not only did he doctor these tapes, but he wrote false minutes on this, and his own tapes will prove that the minutes that he wrote were fabricated to make it appear as if there was a disruption, when in fact no disruption even occurred at the time that he claims it happened. So I guess you'll probably continue this, and we'll take it from there.
Thank you. Since we are not going to have an actual action motion on this matter tonight, we will take public comment on this item now. Is there any public comment?
Good evening. My name is Amanda Nordquist. I am also a street artist, and I had to go through a hearing with the street artist program in November. And after my hearing that I went through, I requested an audio recording from Mr. Lazar so that I could review it for my own personal use. During you all look kind of confused, and I understand why, because it is a very confusing process when you go to one of these meetings. They have an audio cassette recorder that records the hearing. And then when I asked Howard Lazar for a copy of my hearing, he informed me that he first needed to transcribe the audio cassette recording onto his computer so that he could burn it to a CD and mail it to me. And I said, okay, I didn't know. I was like, okay, cool. I got the CD in the mail, and it sounded like the adults talking on Charlie Brown. I could not understand anything. And I contacted the street artist program office assistant, Mr. Lazar's assistant. I let her know. And they basically said, well, what do you want us to do? I said, well, where's the original audio cassette, tape? Can I hear that? And they allowed me to. I had to actually bring my own boombox. I live out in the outer Sunset. Their office is on 25 Van Ness Street. I had to bring my own boombox into the street artist program office and listen to the audio recording. And I brought a blank tape, and I asked permission. Is it okay if I bring a blank audio cassette tape so that I can, with a double tape deck, so I can record it from the original recording? And they said that was fine. I listened to the original audio cassette. I could hear it much better. Also, I wanted to point out that it is standard practice, or Alyssa, the street artist program assistant, had me also go into the library, which is just around the corner from her desk, to listen to the audio cassette tape. And she advised me to close the door behind me because there's a desk right outside. So when I think it was Member Johnson asked if mentioned that the Clark brothers were locked in a room with a cassette by themselves, that's standard practice according to the street arts program office. That's what they had me do. And based on what I've personally seen and experienced from Howard Lazar through my hearings with him, and what I've been seeing here in the past few meetings that I've been attending, what Mr. Lazar has been doing and how he's been avoiding his actions, I wouldn't be surprised if that was something that Mr. Lazar was aware of letting street artists be locked, quote unquote, in a room by themselves with an audio cassette recording, so that in the event that it came to light that he had altered the recording, he could turn around and say, well, maybe it was the street artist because they were locked in the room with it and I wasn't there. But the other thing I wanted to point out was that at my hearing, where I was pressing charges against another street artist for harassing me, I tried to speak about my case, and another street artist was, saying, this victim would like to speak, let her speak, because no one was letting me speak. And Mr. Cancel pretty much yelled at that guy, shut up. So I'm not surprised to see that he would do that to the Clark brothers as well.
Thank you. Is there any further public comment? Seeing none, public comment is closed. Mr. Matos, there is something I would like you to relay to Mr. Cancel. During public comment on an item, or during general public comment, questions are allowed as long as they are relevant to the business of the meeting. There is not necessarily a requirement that those questions be answered, but they are certainly allowed of the speakers. And if he does not want to believe me, he can check with the city attorney.
Okay.
Thank you.
Thank you.
Without objection, this matter is continued to the meeting of April 26, 2011. Thank you all for attending. Mr. Clerk, could you read the next item, please?
Yes, Mr. Chair. Item number 22 is a report from the Complaint Committee meeting of March 8, 2011.
Member Knebber.
We had one hearing. That was Matt Smith versus the District Attorney's Office. We found jurisdiction that for today that complaint was moved forward on request of the complainant. That's all I have to report.
Thank you. The chair will note that the public audience section has been vacated, so I will not call for public comment at this time. Mr. Clerk, could you call the next item, please?
Yes, Mr. Chair. Item 23 is report from the Compliance and Amendments Committee meeting of March 8, 2011.
Member Washburn.
Two matters were referred to us for compliance. One was Mr. Maxwell against the MTA. The other was William and Robert Clark against the Arts Commission. And this evening we took these up. And we also spent some time reviewing the Ethics Commission proposed policy. And we decided to continue that because Member Snyder wasn't there. And he had written some language, and we're now working to finalize this. Hope to have it done next meeting.
Thank you. Again, the chair will note that the audience section is vacated. Could you read the next item, please?
Item 24 is the report from the Education, Outreach, and Training Committee meeting of March 10, 2011.
Okay. Both Chair Chan and Member Cawthon have left. Member Monet, is there anything you'd like to tell us?
So basically, we, if I remember correctly, we revisited the whole idea of the possibility for having a Sunshine Award and how that could work. But we said we would revisit it and before bringing it forward to the full task force. Another thing we brought up was having like a Facebook page, like a social network page where people can just be a fan of Sunshine, so they can sort of know more about what Sunshine is, and on the social networking sites that we could set up, there would be tabs just on outlines, particular cases, notes, things of that nature to give people more information on what that is, and just allowing one person to maintain that so that it wouldn't be like a seriatim meeting or anything of that sort. But again, those were just kind of ideas that Hanley and Member Cawthon and I sort of tossed around. It was nothing really definitive.
Okay. Thank you. Next.
I have that item
Member Johnson?
By chance? I'm just, in my packet, I didn't have item 24. Did anybody else? I'm just curious.
I didn't.
Okay.
No, I don't. No.
I can look it on, it's just the minutes, right, Chris?
Yeah.
Through the chair, it's not ready.
But it was just the education outreach,
Yes.
it's just the minutes? Okay,
Yes.
thank you. Okay, that's fine. I just.
Could you read item 25, please?
Item 25 is the report from the Rules Committee meeting of March 10, 2011.
Member Wolf?
Thank you. I had tried to send a little summary of the meeting, but I was having some difficulty with the city receiving my emails, so get that to you. But the minutes will suffice. We met. It was myself, Member Johnson, Member Washburn. We had a very lively discussion, very informative and well detailed. So the first item was broken out to two areas. One was in relation to quorum. The other one was in relation to voting thresholds. And after almost 2 hours of deliberation, which was very interesting because we were challenging each other, it was actually quite fun for me. I enjoyed it. Don't look at me. Sorry if you felt tortured, but. Anyway, we found that the city attorney's report, or I can't call it an opinion because it wasn't really an opinion, but their report basically stated that since we were essentially voted on by the people of the city, that we are under the charter in every way, shape, or form. But they kept citing Section 4.104D of Article 4, which is under the executive branch. And we are not under the executive branch, and they hold that to be true. The only other areas that particular language is used is under the legislative branch, which is specifically notes the Board of Supervisors, and then other areas for specific commissions, like the Ethics Commission or the Public Utilities Commission or what have you. So we decided that sans finding any reference for a body like ours, that we're not inclusive of that. And so we decided that we could offer a recommendation that we change the bylaws and amend them in Article 4, Section 7 to read, it currently reads, the affirmative vote of a majority of the members of the task force, and in parentheses, 6 votes, close parentheses, shall be required for the approval of all substantive matters. The motion that I'm going to make is that we strike 6 votes and insert the word present. That's my motion.
I second it.
Point of order. I don't. This is a report. I don't think this is. This was an agendized as an action item.
That's correct.
It's noted as an agenda, as an action item on the agenda.
Possible.
And I requested that discussion of possible action.
This is a bit awkward because we have barely. We're talking about the votes, and we have 7 people here right now.
I know.
Right. Is it something that I would also like to? It would be great if we could include some members of the public who comment on it. If we could have it earlier.
Yeah, I appreciate your through the chair. I appreciate your motion, Member Wolf, but I would really like to do this at the beginning when we have people present, like Mr. Grossman, Mr. Crossman, stuff like that, to be able to talk about it. So I would respectfully request that we continue this, but move it far ahead up on the agenda later on.
I want to also, with regards to this, there's one other amendment that we had made in regards to the attendance policy. And I don't know whether you want to do the same for that. It's more of a clarification than it is functional.
Again, I think, again, to the chair, sorry. I think, again, this is a big issue. This is, I mean, it seems like small, but this is big. And I don't think that the end of a long meeting with 7 of us here is appropriate to take this on. I think we should get it earlier and get some public comment in it.
I also think that particularly when we're talking about deciding what constitutes a quorum, what constitutes a majority vote, we need to get some input from the legal community on that. I realize Mr. Grossman is a retired attorney, and I respect his opinions a great deal. He's been a tremendous asset to us. However, we do have an attorney who is a voting member of the task force. Also, I have contacted a number of outside attorneys on this particular question, and their opinions on it vary. Let's put it that way.
Mr. Chair, before we move on, the problem here is that I mean, we had a good attendance today, more or less, but in past months we have not, and so every month that we postpone this, it keeps getting more and more grueling to deal with the public in their angst on this issue. The other thing is that in our own bylaws with regards to making amendments, we have to give 10 days notice prior to any final action, and it's got to be posted on the website, and a copy's got to be sent to the library information center. So it can't just be included in the 3 days prior notice of the agenda. It has to be posted 10 days prior to the meeting. So
is that the action or the actual vote?
the bylaws of the task force may be amended by a vote of the majority of the members of the task force after presentation of the proposed amendments as an agenda item at a meeting of the task force. The task force shall give 10 days notice prior to the final action by posting on the Sunshine Ordinance Task Force website and by sending a copy to the Public Library Government Information Center before considering any amendments to its bylaws.
Member Johnson.
It would be helpful if we had a small write-up of some kind because of what we found, because we had a kind of an extensive discussion and we chose that quorum would be, traditional quorum. But the majority vote would be of the members present. So just to, when we have the legal community weigh in, it would be clear why.
I don't think we need to, I mean, you want to put all that, because that includes Mr. Grossman's summary. It's a ton of public comment around that too. And whatever.
Just that you would know, if you were to ask the First Amendment attorneys, that quorum, we're not saying that quorum is less than 50% plus one.
I think one of the questions on quorum is what constitutes a member, and that's one of the arguments that Mr. Grossman has been putting forward, and Mr. Garza.
That's what I'm saying.
Should a vacant seat be counted as a member for purposes of
But we had an extensive discussion about it because the seats are meant to be filled, and so the law doesn't leave loopholes to leave them unfilled because the force of the law is that those seats be filled. Otherwise, there's no reason to have that many seats. But if you had a brief write-up of it in some way, at least it wouldn't be repeated, is all I'm saying for the legal people. They wouldn't just come back at us with the same argument. They could tear ours apart.
So the six-member quorum, as far as the Rules Committee is concerned, the six-member quorum, the six the six-member quorum requirement stays for a quorum. Is that correct?
For a meeting.
Okay.
Yeah, correct. The whole thing, and no matter where you look around vacancies, the idea is they talk about the expediency of filling those seats. The job, the requirement is get them filled. And if you can't get them filled, then get rid of them. And that's basically, they don't talk about what happens and how they're counted.
Okay.
I would still suggest that we move this to the next meeting.
I realize that. I just want to be sure that we're not, this isn't going to be going on and on. So,
okay, there is a motion. There is a motion to continue. Is there a second to continue to continue this item?
Second.
Okay, moved and seconded. Further discussion.
Just a question: does this
Member
include
Wolf.
include all amendments that we're suggesting?
Yeah.
That the Rules Committee is suggesting?
Yeah.
Yes, that is my motion.
Yes.
All of them. Okay.
I just think that it'd be much better served with a change this big to have it earlier in the meeting with more public comment, more people.
I agree.
Further discussion. Just without objection, this matter is continued till our April 26th meeting. Mr. Clerk, could you read the next item, please?
The next item is the administrator's report. The next complaint committee agenda is going to be pretty lengthy, and it may spill over into the compliance and amendments committee meeting session.
Okay. Member Knebber?
As a added wrinkle, I was going to say this for announcements. I will not be able to attend the next complaint committee meeting. I will be in Germany, so I'll have to. I hope one of you two can be the acting chair and take it on for me.
Okay.
Appreciate it.
Thank you. Member Washburn, in light of what we've just heard, we might want to put the Compliance and Amendments Committee start back to 5 p.m.
Right, and I think that'll be a light agenda, except for ethics. I don't think we have any matters being forwarded. Okay.
Could you read the next item, sir?
Yes, Mr. Chair. Next item is announcements, comments, questions, and future agenda items from task force members.
Colleagues? Motion to adjourn?
Wait, I have a question.
I'm sorry, Member Costa.
One really quick question, maybe just something to think about, is with regard to the article that was published about us, whether or not that merits some sort of response. No. I mean, I know that several members were quoted, so maybe not. But
I think if any member feels strongly about it, then they're certainly welcome and encouraged to send their comments to baycitizen.org and to Scott James, the columnist.
But as a body, I don't think it's not something that we should respond to. It's not.
I don't think it's necessary.
What about the email that Mr. Dorsey sent to Mr. James? It's not necessarily that. I mean, I intend to respond to it as an individual because it's. That's fine. But it's. Mr. Grossman had a point. I mean, that's our attorney, and he's basically saying that we're a kangaroo court in public. I don't know if it's something that you want to address.
We don't have to use the city attorney as our attorney.
Well, what we can do is, I could send a memo to Mr. Herrera asking him if Mr. Dorsey's comment represents the position of the city attorney's office.
Something like that.
I think I will do that.
Thank you.
Motion to adjourn.